petitioner has died, no substitution required because as a teacher he got all the pensionary benefit and retail dues. He has recorded the same with the order. May it appear to be mentioned to your lordship.
To be mentioned more.
May I be permitted to mention which notes, my lord, for hearing?
Hearing, please wait.
My lord, before-
Yesterday I have accepted some slips. Let me dispose of few matters, thereafter I will consider.
Before vacation, I mentioned to your lordship, after vacation, we have-
After vacation, yesterday I have accepted. The first day I have accepted. Because-
I have lost the chance.
Only difficulty is this is not the regular bench. No use unnecessarily adding the matters in the list. Let me dispose of few matters, thereafter I will again allow. Yes,
My
on the
lord,
list.
my lord has disclosed his mind, my lord. But under compelling circumstances, I'm mentioning this matter. This is for hearing, my lord. I must be candid. This is for hearing, my lord. But the problem is that, my lord, during the pendency of the writ petition, now the Coal India Limited are giving the contract to a third party, my lord. There will be a multiplicity of proceeding, my lord. Kindly, my lord.
Hearing not now. Yes, call the
My
list.
lord, grateful.
Item number 5.
We have bring the files 4 or 5 times. My lord, what your lordship wants from that file?
No.
Every time, my lord, we are coming with the brief. Our officer has come.
File is
এক
one
মিনিট
thing.
দাঁড়াও না, এক মিনিট দাঁড়াও, তোমার তো
The,
বলার সময়। What
the
your
day
lordship wants to?
I dictated an order in open
Yes, my
court.
lord, I know.
Thereafter, at the time of signing, I found that some points were missed out.
What that points, my lord? I can clarify
Yes.
that.
Have you seen the order of 12th of September? I have
Yes.
indicated that.
Yes, my lord. No,
You
my
have
lord,
seen?
I have not. No.
Kindly go through this order. For this, I have directed you to keep an opportunity of hearing. This order has not been uploaded.
Yes, Lordship.
My lord, in this matter, my lord, that is 9(3)(b) was there.
Yes. So first part, there is a legal issue that was not addressed. None of you have made submissions on that. I thought
As my
that
lord, 9(3)(b) is my lord started. So my lord, other point is
that
automatically.
is why that point was not argued. For that, I have kept it for further hearing.
Yes, my lord, I have seen, my lord.
Yes.
As no ever
So
first part, my
when
lord,
you will be ready, when both of you can make your submission.
Yes, my lord.
When?
My lord, today, my lord, my London friend is
The
not.
pan has come today.
No, Lordship. Lordship, before starting the argument further, Lordship, it is necessary to.
It is necessary to, my lord, to bring the records.
Yes,
And
Lordship.
every day we have come with the records.
Because,
He-
Lordship,
he, my
our
lord,
submission is that, Lordship, no
Very
notice
bad.
under section 9(3)(b) was issued. So, Lordship, last order, Lordship, last paragraph. Mr. Pan, learned advocate appearing for the petitioner submits that the case on hand, no notice under section 9(3)(b) of Act 1 has been served upon the writ petitioner. So, Lordship, according to
Only
that,
for this whether Mr.
9(3)(b) notice was
9(3)(b)
there or
notice
not?
was served or not. For
Yes,
that,
Lordship.
I have directed production of the original file to ascertain whether that was served or not. Only for that purpose. That is factual part. And the legal issue is that where a notice under 411 was issued and was surviving, but no order was passed, whether the proceeding could be revived by issuing a 9(3)(b) notice or
yes,
not.
my lord, it is automatic. As because, my lord, that is 9. My lord, that part is, my lord.
Like, there are some points there, Mr. Dey, because I thought it
For the,
fit for further hearing. If you are ready, I can place it any day. You address the
Yes,
court
my
on that because those points were not argued. And while passing
as
the order, I
because-
also, it went out of my mind. So an order was passed. That is why I recalled that order and kept it for further hearing
Well, your
to
lordship
enable
said-
both of you to address this.
My lord, as your lordship said, my lord, that is if the first part is not complete. My lord, first part is not complete for that reason 9(3)(b) was there. First part was not
Right.
there.
So when Mr. Pan
Kindly keep this matter tomorrow, lordship.
tomorrow,
Tomorrow, my lord, yeah, my lord, your lordship will sit tomorrow.
Thursday,
Thursday,
Thursday.
আজকে যেমন ফ্রি ছিলাম,
Thursday you can come.
I
Thursday.
may come,
Thursday, স্যার আপনাদের হলিডে আছে সেদিনকে আনতে পারবেন রেকর্ড?
record আসতে পারবে। On that day, my lord, our that is there is a state holiday, my lord, for that reason.
State holiday.
Next, my lord, your lordship can fix Thursday.
Thursday week.
Yes, my lord.
Week.
All right, 14th.
Yes, my lord.
Uh,
I bring my lord, there is, I have so much, I have the knowledge, my lord. We have, my lord, in the sheet, my lord, there is a demarcation that notice was served and date was there. But so far my knowledge goes, my lord, but that notice we have not searched in the file. If your lordship wants to see, my lord, I must come with the.
Mr. There are two parts. That is the
Yes, my
factual
lord,
part.
first part and second
That
part.
is the factual part. First part is the legal issue. 41A notice
Issue.
issued. It was valid as on 31st of March
1990.
1997.
Yes, my lord.
It would expire sometimes thereafter. Now, whether in such a case, the proceeding can be, but no award was passed within the time contemplated under 7A. Here also no award was passed. Now, under such circumstances, when the notice was surviving after 31st of March, whether such a proceedings can be revived under 9(3)(b, that is the legal issue.
My lord, already.
That is the legal
Why
issue in, and if yes, then-
why amendment was there? Only for that.
so
reason.
address the court on that issue because
Yes,
that
my
is the legal issue.
Yes, my lord.
So whether 9(3)(b can be issued for reviving that
Yes,
proceeding.
my lord.
Address the court on that issue because the other judgments subject to correction by both of you did not deal with those aspects. Full bench, other judgments. That is why I kept it for further hearing. Ashun. As jointly paid by the learned advocates for the respective parties, list this matter on November 14,
Yes, my lord.
2015, under the same heading. It
My
will
lord,
appear under the heading
My
continue.
lord, we bring the records.
Yes, because there
My
are two
lord,
aspects. One is legal part.
My lord, if
If you succeed on the
my
legal,
lord, if your lordship will sit in the division bench, I pray, my lord, your lordship can at 4, your lordship can sit in a single bench on Thursday. That is 14th. On
since
the
usually-
previous occasion, my lord, we have come with the all
Right.
records, but your lordship only passes judgment and your lordship. Rise.
kindly do one thing. Both of you ask your juniors to intimate my officers. I will think. and
I
process
can
on-
intimate, my lord.
হচ্ছে ওই 14 তারিখে হ্যাঁ একটু অন্তত মনে করবেন যে কোনো একটা টাইমে আমি ফিক্স করবো কারণ রেকর্ডস প্রোডাকশনের কথা আছে তো একটা টাইমে বসে যাবো 4টের সময় হোক বা যা হোক ঠিক আছে সেটা তুমি আমাকে তার আগের দিন মনে করিয়ে দেবেন অলরাইট আই উইল কনসিডার
Yes.
Happy district.
and one thing your officers will come before 4 so if you can give inspection to Mr. Pan with regard to
We have given me.
No, with regard to that part, 9(3)(b only. Give inspection so that they can be also ready and can make arguments on that.
Also given to.
9(3)(b,
Yes, my lord.
copy given. All right, given inspection of that. Yes, call the next matter.
Item number 11.
Under item number 11, I beg to appear on behalf of the petitioner through virtual mode, my lord.
Yes, yes.
My lord, yesterday this matter was taken up for consideration when my lord, since none appeared on behalf of the alleged contender, my lord was of the opinion to direct a notice, to send a notice to the alleged contender mentioning the matter is adjourned for the day. My lord,
Yes.
that has been done. My colleague is, my lord, my lord is placing the notice. We have served them by hand and they have received it yesterday itself.
Mr. Chakravarti, who has been entrusted?
My lord, entrusted is the alleged contender is the regional general manager, respondent number 5 in the writ petition, who was directed by an order dated March 21st,
Who
2020.
appeared in the writ petition on behalf of them?
And none appeared. None
None
appeared.
appeared.
None appeared.
No, Union of India, I find Sunil Kumar Singhania and
No, my
Bilkul
lord,
Kaur-
Sunil Kumar Singhania appeared, but thereafter, my lord, at the time of final adjudication, in spite of notice, none appeared. If my lord take note of the order dated page, order dated March 21, which is at page 19 of the instant application. Sunil Kumar Singhania represented them, but the direction which was passed, my lord will find that at page 20 onwards, paragraph 3. The direction was upon me to serve a copy of the representation upon the regional.
Who appears for Shipping Corporation, Mr. Chakravarti? Do you know who appears for Shipping Corporation?
I'm sorry, my lord, I'm not aware of who
All right.
generally appears.
Ashwin.
This is the third time when we have served them notice and they have not appeared, my lord. First occasion, my lord was kind enough to direct a service of the copy of the application. After that, my lord, on 5th September, again, it was directed to serve a notice, and now yesterday was the last.
Pursuant to the order dated 4th of November 2024, a notice has been served upon the alleged contender, intimating that this matter will be taken up today. However, in spite of notice, none appears for the alleged contemners.
My lord, one contender.
Alleged contemner, full stop. In view thereof, this court would have been well justified in issuing a rule against the alleged contemner. However, in order to afford a last opportunity to the alleged contemner to represent in this contempt application, list this matter on November 14, 2024, under the same heading. The learned
Madam.
advocate on record of the petitioner is directed to communicate this order to the alleged contemner and file an affidavit of service on the next date.
My lord.
Mr. Chakravarti, ask your junior to file a affidavit with regard to this yesterday's.
My lord, may I
Notice
take
का
back this letter? May I take back this letter?
একটা লিখে দিন, leave is granted to the learned advocate on record to file the affidavit of an affidavit of service incorporating the acknowledgement of the alleged contemner on the learned advocate's communication letter dated 4th of November 2024.
Well.
To file, leave is granted to file to in course, comma diye in course of this day.
My lord.
Yes, next.
12.
Well, my lord, I am for the petitioner. My lord, previous occasion, my lord, I took time to file affidavit in opposition. I requested the district judge to come, but up till now they did not.
Mr. De, have you seen the,
Yes, my lord, I have seen the judgment. My lord, they give me an instruction,
according to them, it is a covered matter.
covered matter, my lord, only one thing, my lord, that is that they filed one application, the representation before the authority, my lord, that the district judge.
If
has
it is a covered matter, what you will do with the representation?
My lord, in view of the judgment, one bench clerk and one group D covered. And my matter, my lord, only two bench clerk.
To bench
But
clerk.
pursuant to the same notification, they have been appointed, same, everything are same. And also, my lord, you will also kindly, my lord, permit me just এইটা দিন তো এইটা the certain correction I have made. If your lordships permit me, my lord, in the second same matter, I have
Oh.
corrected, my lord, the
You have made the correction.
yes. Because there are three writ petitions. There in that writ petition. In this writ petition, two bench clerk.
Two bench clerks.
And same district judge Nodia.
So you want the effect of 14th of August 2008 and 16th of September 2009
Nine.
notifications.
From the date of joining their respective post.
Yes, from their respective dates of initial joining the service.
Yes.
Sir, they have you considered this?
Yes, my lord. Consider, my lord, only as per my instruction of by the landed district judge, my lord. That is, he requested me that should be sent to the authority to consider and dispose of it.
What consider? The court has decided the issue. Now what you will consider?
What my landed district judge, my lord, requested
This
me
could have been if you have done earlier. Now it's the matter has been settled.
Bivas Chandra Saha's matter, no appeal has been papered. Also, no appeal has been papered. The Honorable Justice Sambuddha Chakraborty, Dr. Sambuddha Chakraborty. That no appeal has been, that order has been complied. My lord's also no appeal has been papered. So this has been, my lord, the only remaining two bench clerks, my lord,
I have seen, my lord, everything, but
The petitioners, two petitioners,
two petitioners.
the petitioners have paid for issuance of a writ of mandamus commanding the respondents to pay remuneration and other allowances to them from the respective dates of their initial entry into the service in accordance with the notification dated 14th of August 2008. Stop. The তারপরে এই জাজমেন্টের না এটা একটা কারেকশন করা আছে, সেট আউট প্যারাগ্রাফ 2, ওইটা করে সেটা এই কারেক্টেড এইটাতে, ঠিক আছে? সেট আউট প্যারাগ্রাফ 2 হবে। প্যারাগ্রাফ 2 এর পর 4, এই রে, না 3টে, 2 এর পর 4 একটা প্যারাগ্রাফ মিস গেছে এখানে, টাইপিং 2 এর পর 4 হয়ে গেছে দেখছি। না 3 আছে তো। Yes, তারপরে 4, সেট আউট প্যারাগ্রাফ 4, তারপর প্যারাগ্রাফ 5। Heard Mr. Jana, learned advocate for the petitioner, and Mr. De, learned additional government pleader for the state. The issue involved in this writ petition was considered by this court in a writ petition being WPA 3364 of 2019 in the case of Saiful Gain, Gain, and others versus State of West Bengal and others. And an order was, and a judgment and order was passed on 2nd of August 2024. The petitioners herein are similarly situated with the petitioners in Saiful Gain within bracket Supra. First up, in the said decision, it was held as follows. বলে এরপরে না কারেক্টেডটা নেবেন না, এরপরে ওইখানে কারেক্টেডটা আগেরটা, এবার হচ্ছে মেনটাতে নিয়ে নেবেন। এখান থেকে সেট আউট করছি তো, আবার ওখানে কারেকশন দিলে মুশকিল হবে। এক মিনিট। এইখান থেকে প্যারাগ্রাফ 15 এর না, ওই এইখান থেকে নেবেন, হ্যাঁ, প্রথম লাইনটা বাদ দিয়ে দেবেন, ওই ডট ডট দিয়ে যেরকম ভাবে হয় এইখান থেকে করে এই পর্যন্ত 26 এর এই পর্যন্ত ব্র্যাকেট দেওয়া পর্যন্ত, 26 এর ব্র্যাকেট দেওয়া। The said decision squarely covers the case on hand. First up, in view thereof, the writ petition stands allowed the same respondent numbers 1 and 2.
And two.
The respondent numbers 1 and 2 are directed to take immediate steps to release the remuneration and other allowances to the petitioners from the respective dates of their initial joining into service in accordance with notifications dated 14th August 2008 and 16th September 2009, as well as any subsequent notifications after adjusting the payments already received by them as expeditiously as possible, but positively within a period of 8 weeks from the date of receipt of the server copy of this order. First up, paragraph. It will also be open to the said respondents to call for any records from the concerned district judge, and if such request is made, the district judge concerned is requested to comply with the same at the earliest. No cost.
Instead of
urgent,
1 and 2, my lord, 2 and 3. That will be better.
respondent numbers 2 and 3.
2 and 3.
District
One-
judge has
one
a
state-
role, my lord.
2 finance department and 3
Finance
district judge.
district judge role nahi. My lord, that is the
1 state of West
policy.
Bengal.
That is
2
the
and 3.
policy matter of the state,
Three
my
is
lord.
the
So
district judge has
district
done
judge
it.
has
One
one
and-
role, my lord.
1 and
1 and 2 is
very,
the
very.
Yes, my lord.
district
One
judge
and-
shall only forward.
Only
District
Yes,
judge
my lord.
cannot do
Yes, my
anything.
that is the
That is
state
why I have
policy.
directed the district judge to forward only those.
Yes, my lord.
And my lord, the paragraph 3 of your lordship's earlier judgment, my lord, the additional district judge Tehatto Nodia, in this case Krishnanagar Nodia, both the cases.
যায়নি, my lord।
দিয়েছে কিনা কি জানি, দিয়েছে কিনা জানি।
এ করে-
কৃষ্ণনগর নদিয়া instead of তেহট্ট,
Oh, instead of
তেহট্টা।
তেহট্ট এই প্যারাগ্রাফ 3 টাও আছে বুঝলেন ওইখানে
প্যারাগ্রাফ 3 both, my lord, the entire
আমি
paragraph.
যেটা corrected একটু বলেছিলাম না, two আছে। ওইখানে ডিস্ট্রিক্ট শুধু 2 হ্যাঁ 3 হবে 3 এর এই ব্র্যাকেট পোরশন পর্যন্ত এইটা হচ্ছে অ্যাডিশনাল ডিস্ট্রিক্ট জাজ নট তেহট্ট
কৃষ্ণনগর,
লার্নেড অ্যাডিশনাল ডিস্ট্রিক্ট এন্ড সেশনস জাজ কৃষ্ণনগর
কৃষ্ণনগর, কৃষ্ণনগর নদিয়া, ডিস্ট্রিক্ট জাজ সেম, নদিয়া,
কোনো অ্যাডিশনাল ডিস্ট্রিক্ট জাজ ডিস্ট্রিক্ট এন্ড সেশনস জাজ
নদিয়া
কৃষ্ণনগর নদিয়া। কমপ্লেন, ঠিক আছে? একদম I have received everything, all benefits.
both the petitioners
Both the
কৃষ্ণনগর
petition, both the petition.
ঠিক আছে একটা হচ্ছে কারেক্টেড থেকে পরের পার্টটা কিন্তু আনকারেক্টেড থেকে yes thank you Mr. De.
Yet to do.
Yes, next.
Fourteen.
The 14 who is appearing
Lord, I beg to appear for the petitioner, my lord.
I for the private.
petitioner
I find my affidavit of opposition.
So I'd like to file my affidavit.
yes
Lord, may I? My lord, petitioner is a contractor, my lord, who, my lord, takes ferry ghat on lease.
adjust your mind
My lord, petitioner is a contractor, my lord, who takes ferry ghat on lease as a mode of business, my lord. Now, my lord, a tender was floated, my lord, in July 13, 2020, my lord. Which your lordship will find the
what
notification.
is the period of tender
That tender, the period for the ferry ghat operation was for 2 years, my lord, from 20 to 22, my lord. Now, my lord, I was a participant in that tender, my lord. My lord, I went for the auction. My last call was, my lord, 50 lakhs for the 2 years period, my lord. My lord, I was defeated by another call, which was 50 lakh 5,000, my lord, and I lost, my lord. I was not the L1. So, my lord, naturally, my lord, I waited for next 2 years in expectation that after 2 years, again the tender will come out, my lord. Again, I will participate in the auction, my lord. My lord, nothing that's what happened, my lord. There was no advertisement, my lord. I made representation, my lord. No, nothing, my lord. No reply, my lord. Then I made reminder, my lord. Then also I could not get any reply, my lord. Somehow I came to know, my lord, from rumors, my lord, that the lease that was granted in 2020 has been extended in favor of the erstwhile L1, my lord, by the Jilla Parishad, my lord. My lord, that was my cause of action, because of which I come up before your lordships, my lord, challenging the extension order, which your lordship will find at
What was the period of lease?
lease was initially 2 years as per the
That was 22.
22.
Subsequent lease,
3
what is
years,
the
my lord.
period?
3 years.
3 years.
Yes, my lord.
So it will expire on
25 July 29th, 2025, my lord.
29 July 2025.
My lord.
Private respondent has been
Yes, my lord.
favored with the.
Yes,
You are appealing for the private respondent.
Yes, my lord. Now, my lord, that is the long and short of my case, my lord. Now, if your lordships kindly takes up the documents, my lord, I will place, and then I will take your lordship straight away to the affidavit in opposition of the state, my lord.
According to you, it could not have been extended without holding an auction.
Yes, my lord. That was my initial case, my lord. But now, with the affidavit in opposition of the state, my lord, there is something more drastic that will come up before your lordships, my lord.
Affidavit of the state.
Yes, my lord.
Where is the affidavit of the state? State means respondent number 5.
7, my lord. 7 or
Respondent
5,
number
5,
7.
5. No, man, 7 is the private respondent.
5 is
5.
the state. Have you used any reply? No.
No, my lord.
Yes.
Things are admitted, my lord. Lordship is in the affidavit in opposition, my lord.
Yes.
lord.
Opposition of respondent number 5.
Yes, my lord. Kindly takes, my lord. Page number 3, my lord.
Yes.
Question number 2, that they have themselves, my lord, framed.
Yes. What do you want to show from this?
Yes, my lord, lordship has seen question number 2, my lord, that they have themselves framed, my lord. The question I'm placing before your lordships, my lord, whether public auction is to be compulsorily adopted by the public authorities in awarding lease license of any public property for extending service to public in general. And emphatic answers they have given as yes. And then they have sought to justify why this course was not adopted in this present case, my lord.
Yes.
Now, my lord, if your lordship sees that they have relied upon a resolution which is dated, my lord, 9/6/2022. If your lordship goes on reading it, my lord, lordship will find, if I read for your lordships, my lord, lordship is on page 3, my lord.
Yes. Where is that resolution?
My lord, that resolution, lordship will find at page 18, no, my lord, I'm sorry, 21, my lord.
There is no 21.
My lord, page 20, I'm sorry, I stand
20.
correct, my lord, 20. My lord, kindly sees the date of the resolution, my lord, first.
9th of June 2022.
Yes, and kindly sees the extension order date.
Where is the extension order?
My lord, the previous page. 19. Now they have a justification, my lord, which I shall place. What they say, my lord, is that this is a post facto approval that they have given, my lord. Now kindly see the post facto approval language of it, my lord. What is the basis of this approval? If your lordship takes the resolution at page 21, second, my lord.
Page,
20, my lord, the resolution.
yes,
My lord, if I may place it, my lord, in the first, second, the third, second bullet points. The second bullet point, the second paragraph, my lord. Manoniyo, it starts with Manoniyo, my lord.
yes.
I'm placing it. মাননীয় অতিরিক্ত জেলা শাসক তথা অতিরিক্ত নির্বাহী আধিকারিক মহাশয়ের পরামর্শ অনুসারে. So, my lord, this is the reason that why this post facto approval was given, my lord. That the official has asked him or directed them to take a resolution, and that's why they have taken a resolution.
Additional district magistrate,
Yes, my lord.
yes.
Now, my lord, this is one part, my lord. Now, my lord, kindly see the most pernicious part of it, my lord. Like I submitted, my lord, that initially I participated in the bid. My call was 50 lakh. I lost by a margin of 5,000. He was the highest bidder with his call as 50 lakh 5,000. Now it transpires, my lord, that auction was also manipulated. My lord, kindly takes up their own documents, my lord, the affidavit in opposition, my lord.
We cannot go into that auction, it has lost its force.
My lord, why
What
I?
is the use of going to that?
Because there is a prayer to that effect, my lord.
What prayer?
A thorough investigation, my lord.
It will-
If your lordship don't want to go
How
in,
it will help it?
my lord, there is something amiss in this whole transaction, my lord. If your lordship is inclined to order an investigation, your lordship may. Otherwise, my lord, I will restrict myself, my lord, to my own interest, my lord. Very well, my lord. If your lordship don't want to go into that, I will not, my lord.
Yes, who is appealing for the state? You are appealing for the state, yes. Madam, kindly use the microphone.
Yes, my lord, that
How could you extend this lease without going for an auction?
was a period of COVID, my lord. It was a period of COVID, that's why I was done.
For a period of,
COVID.
for the period of COVID, where does your resolution say so?
Resolution,
So, and 2022 also COVID. So in 2020, you could hold an auction.
should have been done.
So at that time, no extension. There was no COVID in 2020. No COVID. In 2022, COVID came.
I can't go beyond this affidavit. I couldn't go beyond this affidavit. Beyond this,
Your documents do not show COVID.
no, my
Then justify from your documents. How could you extend this lease?
If your lordship come to paragraph 8, my lord.
Paragraph
8 of my opposition.
of your opposition.
Yes.
Yes.
As per recommendation of কর্মদক্ষ ও পূর্ত কর্ম পরিবহন সমিতি and Sabhapati of Malda Jilla Parishad, the Balarampur Ghat, erstwhile Pirganj Ghat, was extended 15% enhanced rate per year of previous lease for the period of 37/22 to 29/7/25.
I for 3 years, write memo number such and such. And the extension was done, my lord.
Yes,
And it was approved by the,
recommendation.
yes, ma'am.
So in July also you will recommend
And
for
it was-
another extension of 10 years.
No, my lord, not for 3 years. No,
No, in July 2025, we will give a further extension of 10 years.
no, no,
Why?
If you are again.
Why
auction-
extension was granted without holding an auction, and lease was granted prior to this decision being taken?
I can't go beyond this record.
What do you now propose to do?
But, for further auction may be held, my lord. For at the expiry of 25th July 25, my lord, let a auction be held. I will propose that, my lord, in accordance with law. What else can I do?
Yes,
Lordship, what the
please use the microphone.
Lordship, what the petitioner is trying to say, Lordship, is that in the year 2022, the auction price was 50 lakhs 5,000. But Lordship, they have not shown a single document that it was 50 lakh 5,000. It was 21 lakhs. I was the highest bidder. I was given the lease. I ran that lease. Now, Lordship, what happened from 2020 to 2022? COVID hit in during that period. I had a substantial loss because most of the time the ferry guards were closed. I could not earn my sufficient in revenue. That's why, Lordship, if you Lordship kindly sees my affidavit in opposition, Lordship, I made a prayer before the concerned authority for extension of the lease period. And Lordship, on that basis, this lease period was extended for another 3 years. At an
Show me from their document that considering your prayer, it was extended. Show me from the documents. You may have made a prayer, but that was considered and a decision was taken on your representation. Show from the
Lordship,
documents.
kindly come to page 13 of my affidavit in opposition, Lordship. I
13, yes. Yes, that is your prayer.
that is my prayer.
Yes.
And on the next
Show me
page,
that it was allowed in your favor,
Lordship, kindly,
considering your prayer.
kindly come to page 14. It does not mention that my prayer was considered, but Lordship, kindly see, it was enhanced at a rate of 15%, enhancing from the previous year. The total amount was 1,93,000 and odd, and Lordship, I paid that entire amount. In few installments, I have paid that entire amount, and only 8 months is left for the lease period to close, Lordship. Just because I had,
You are agreeable to pay more
My lord,
than this.
My
How
lord.
much?
my lord, lordship, my lord, fixed, my lord.
How much? Give your price.
My lord, I already gave a price of 50 lakh on the previous
No,
occasion,
no,
my
no.
lord.
This
For
time
2 years.
for the November has started. From December, January, February, March, April, May, June, July. 8 months.
My lord.
What will be your figure?
Whatever he has paid, the double of it, my lord.
Yes, madam.
Lordship, I've already paid for the entire period,
You will
Lordship.
get that amount. You will get that amount for 8 months. They will refund it and double that amount. The state exchequer.
No, Lordship, I understand, but Lordship,
You
if
will
he,
get back your money.
no, I'm saying a different thing. If he is agreeable to
You
pay,
will not incur any loss.
no,
You
if
get
he
back
is,
that amount.
if he
What
can,
you have paid.
if he can pay the double amount of what I am
Yes, yes.
paid of the 8 months, Lordship, my client will definitely propose for an enhanced amount of what he pays.
Yes. How much you will propose.
This will go on, Lordship.
Yes, yes, yes.
This thing will go on.
Let us see
But
how far
Lordship,
it can
kindly,
go.
but Lordship, kindly appreciate,
So you can match double the amount.
and this will go on.
No, no, no. I'm asking you. You can. How much you can pay
In
for
fact,
this?
in fact, more than what he pays. More than what.
Quote an amount. Quote an amount.
Then,
Let
Lordship,
us see.
then the amount for the next 8 months has to be fixed. What is the
Yes.
figure of, let the state
Yes,
come and
for
fix.
1 year you have quoted how much?
Lordship, kindly come to page 14 of my opposition. The details is
Yes.
given there.
15 lakh 96. So almost 16 lakhs.
Almost 16 lakhs.
16 lakhs. So for 8 months, how much it comes?
Has to be calculated. Has to be calculated.
Calculate. Let us see where it stops.
1.333. 1.33 lakhs.
1.33
lakhs per month.
per month.
Per month. Then for 8
So you
months,
want to double it.
8 months
So
it comes to
2.66 per
10
month.
lakh 66,000 and odd. For 8 months it comes to 10 lakh 66,000 and odd.
10 lakh 66. So you want to pay double that amount.
That has already been paid, Lordship. I have paid at the
No, no. You are agreeable to pay. He is agreeable to pay double that amount. You will get back that amount.
I'll pay more than him.
How
I'll
much?
pay more than
20 lakhs 66 or
let
21
him
lakhs you will pay.
if he pays double, I'll definitely pay
No, no,
more
no,
than
no.
him.
I'm asking
To
you,
retain my
are you agreeable to pay? You have said you can pay double that amount. Are you agreeable to pay 21 lakhs?
No, I never said I'll pay double. I said I'll
Have
pay
you
more.
taken
I'll pay more than him, Lordship.
Sir, have you taken instructions from your client?
No, Lordship.
File an affidavit that you are agreeable to pay double that amount.
Lordship, let me take instructions, then Lordship, I'll come back. Give me 1 day time, I'll come back tomorrow.
Yes.
My lord, may I make a short reply, my lord?
Time, Lordship.
He just quoted that amount, my lord. Now kindly see how that amount got reduced from 50 lakh 5,000 to 21 lakh.
Lordship, I have a question. Lordship, 50 lakh 5,000 was never there.
My lord, may
How
I
can he
place?
show?
All right.
Let him
So,
show 50 lakh 5,000.
let us see how much and take instructions from your
Lordship,
client. How much your client can pay for these 8 months.
And Lordship, one more, sir.
The highest amount, you can we can direct them to hold an auction
That will be the best course of
between
action.
you
And Lordship,
for these 8 months. And
state should bring an instruction whether the amount was at all 50 lakhs or not. It was
No,
21
no.
lakhs.
Now we are not on 15. You have quoted, this is page 14. From 30th of July to 29th of July 2025 is 15 lakh 96,919. You are agreeable to pay double that amount for these remaining 8 months. So take the instructions from your client.
He said he'd pay double.
He said he will pay more.
He said he will pay double.
Yes,
I
he
said
said
I'll
he
pay
will
more
pay
than-
double. You said you are agreeable to pay more than that.
Yes, definitely.
So you are agreeable to pay
I'll take instruction.
at least double.
I'll take instruction and I'll come back, Lordship.
Ashwin. The petitioner alleges that after expiry of the lease for running a ferry ghat, the respondent authority extended the lease for a further period of 3 years by way of private negotiation with the private respondents without holding any
One private respondent.
private respondent without holding any auction. Full stop. The learned advocate appearing for the state submits that pursuant to a
My lord, a resolution.
submits that pursuant to the recommendation of the কর্মাধ্যক্ষ of পূর্ত কার্য ও পরিবহন, এটা না পেজ প্যারাগ্রাফ 8 of fifth respondent এর এও থেকে আছে, স্থায়ী সমিতি and সভাধিপতি of মালদা জেলা পরিষদ, the lease in respect of Balarampur Ghat was extended at the rate of 15% enhanced rate per year of the previous lease value. Full stop. Record reveals that the additional district magistrate by a memo dated 22nd of April 2022 granted extension of the lease period of Balarampur Ghat in favor of the private respondents with effect from 30th of July 2022 to 29th of July 2025. Record further reveals that the decision for the decision for extension of such lease was taken subsequently, that is on 9th of June 2022. First up, the learned advocate appearing for the state submits that since that due to prevailing COVID-19 pandemic, the lease was extended. First up, however, this court fails to appreciate as to why such extension was granted in the year 2022, when in the year 2020, the authorities could hold an auction for the purpose of granting lease for running the said ghat. First up, in course of argument, the learned advocate appearing for the petitioner submits that the petitioner is ready and willing to pay the balance amount as quoted by the private respondent. Balance amount is to pay an amount double the amount at which the lease was granted in favor of the private respondent for running the said ghat for the period from 30th July 2024 to 29th of July 2025. Yes, that was the initial. So I've said in 2020, I've said. At that point, you could hold an auction when there was no COVID. But 2022, COVID came. In reply to such submission, the learned advocate appearing for the private respondent submits that the private respondents shall pay an amount more than the amount which the petitioners are ready and willing to pay for the balance period. However, the learned advocate for the private respondent seeks an accommodation to take necessary instructions from his client in this regard. First up, the petitioner and the private respondents are directed to quote an amount for the balance period quote an amount for the period from 1st of December 2024 to 29th of July 2025 in a sealed cover which shall be produced before the court on the next date.
Lordship,
So both of you quote the highest court will grant to him.
Lordship, one more thing, Lordship. since I paid this last installment of 15 lakhs 96,000,
That you
this
will get.
amount may be adjusted. Let this be.
Yes, yes, that the court will consider. Why are you afraid? You can match a higher figure. No amount of adjustment, you will be paying only the balance amount. Why refund? Quote the rate in the sealed cover, the highest, you take the money. Yes.
But until unless I know his amount,
No, no, no. This is,
he said he will pay the double.
you quote a higher figure. You are a businessman, you know. You quote a higher figure,
So taking
he
into
will also not
consideration
know
double
your
this
figure.
amount, I'll hold
He will
high.
also not know your figure.
No, I'll take into consideration double of this figure, 15 lakh 96,000.
Maybe
I'll
he
go-
may say 3 times, he will say 4 times. So the highest which you can pay.
go on.
You quote a highest figure, he will quote a highest figure. The highest of both of you, the court will grant. After all, you are businessman, you have to take your decision based on that.
Go on. How do I
You
know?
quote a figure,
But if it
you
comes
have
to
said more than
more
he
than
quotes.
he, what he,
So
if I don't know what he is paying,
you quote a figure. You quote a figure, the highest of the thing that will be given. Now there is no COVID.
so now
Now there is no COVID. So the highest figure you pay.
no, state has never cited the reason due to COVID they are not holding the auction. My prayer was
That is a submission. Not borne out from the records. List this matter on November 14, 2024.
Lordship, can it be on 13th or the next on
14th,
14th, Lordship? I have their personal difficulty, Lordship. On 13th or on 18th, any date, Lordship. 14th.
you can appear online. You can send someone with that sealed envelope.
Lordship, I'll not be here. That's why. Because I'll not be in town. 14th. Only one day. If 13th is fine. 13th or 18th.
14th, I do not know. 13th, 18th are uncertain for this, so far as this court is concerned.
But Lordship, but then if I'm not able to appear, Lordship, an accommodation, I'll pray.
You can join virtually.
I'll be not here. I'll be out of station. I'll be out of station, and
You cannot join virtually also.
from there I won't be able. Some personal difficulties there on 14th, Lordship. Any day other than the 14th.
13th করে দিন.
13th is fine. 13th.
Yes, call the next
I'm
matter.
grateful.
Well, kindly take it up at 2 p.m. in this matter. Mr. Parthopati Brai is appearing for the petitioner. But
He
he's
will be busy at 2
no,
p.m.
he's arguing a matter before the division bench. Court
He's a
number-
busy counsel. You
No,
start.
he will. But he will. On last time he argued the
He
matter.
will be busy in civil courts.
No,
Civil
no,
motions.
My lord,
Order 41, first
No.
appeal.
Lord, he is ready. Lord, yesterday he was there. If your lordship kindly take it up at 2 p.m.
2 p.m.
Court. My lord.
Yes.
16.
Sir, I am appearing for the petitioner.
I'm appealing for the SI corporation.
Yes, I'll.
My lordship, Mr. Galib is for the state.
Oh, that matter. Yes. Who is for the state?
Mr. Galib is for the
Where is he?
on his legs in code 11, my lordship. On his legs in code
On his
11.
legs.
Yes, my lordship. Kindly fix
Alright.
it at 2.
He will be joining.
Let me, I will take some
Let
time.
Mr. Bera
Let me
start.
proceed.
Inform him.
My lord. Now,
That is
after
the balance land.
balance land. My lord, according to us, my lord, requisition was in respect of 12.46 acres. Then, my lord, 418 notification was published in respect of 10.34 acres, keeping aside 2.12 acres of land.
That is the disputed
That is
land.
the disputed
You
land.
want
Then
return of that.
return
or
or acquisition or
compensation
compensation,
for
whatever it
that.
may be. If it is returned along with requisition compensation, that is here. You are around here.
This matter I'm led by Mr. Ghali.
Yes.
Yes, Mr. Galib is coming. You are also there.
Yes.
Yes.
Number repeatedly, this court was pleased to direct produce the possession certificate. Now, ultimately, no possession certificate could be filed on behalf of the state. They filed a reconstructed part of the reconstructed records without possession certificate. The preliminary report, the order of requisition, the copy of the award in respect of 10.34 sub, that bunch was filed. Number three, subsequently, the requiring body appears. They appearing, they submitted some documents in respect of possession. Similar, in respect of them, they said, we got possession of 10.34 acres of land.
How much?
10.34 acres of land. So, my lord, this dispute, they are now disputing as if we have not taken possession of 2.12 acres of land. If possession is not taken, then something else they will say, we have not taken possession.
The requisition notification was for 12 point something.
12.46 acres.
418
notification 10.34 acres. The possession certificate as produced by the requiring body.
বাঁধানো একটা আছে না?
Has your lordships got Act 2 of 48? Number
The Pan was kind enough to give this.
Number you are going into that mirror. I want to submit your lordships. Then mirror kindly read. I will read along with your lordships.
All right, give me 1 minute. I will.
Section 3. Section 3. Kindly read section 3.
Yes. Yes.
This is most interesting.
Yes, section 3.
Section 3. I will read along with your lordship. Number first, subsection 1. If the state government is of the opinion that it is necessary so to do for maintaining supplies, etc., services, etc., I am skipping over that. Kindly read last 3 lines. The state government may, by order in writing, requisition any land and may make such further orders as appears to it to be necessary and expedient in connection with the requisitioning of requisition. So, it must be when government requires that this land is necessary for this purpose, they pass an order of requisition in respect of a particular portion of land. Then, Miller provided no land use. I am skipping over that.
Come to 2, subsection 2.
Yes, subsection 2. Not only that. Then, Miller, subsection 3 also it will be necessary.
Yes, first subsection 2.
First subsection 2. An order under subsection shall be served in the prescribed manner on the owner of the land, and where the order relates to land in occupation of occupier not being the owner of the land, also on such occupier. I will be harping on this. So, in requisition land, a particular area of land is requisition. The owner may not be in occupation of the entire portion of the land. It may be occupied by some other persons also. And if that is in occupation of other persons, then the order of requisition shall be served upon them also. Upon the land owner.
Requisition has been defined anywhere in this.
Requisition, I think the requisition has not been defined except section 3.
So this is an order.
This is an order.
An order has been passed. Subsection 3, if you come, failure to comply.
Yes.
So an owner has to comply with such an order.
Yes, that is the duty incumbent upon the landowner. So the government will approach that handover, deliver possession. The order has been served. No case has been made out. We have not complied with the order. And it is not only that, we have not complied with the order, that is not. And not only that, your lordship, later part of subsection 2, if it is in occupation of other person, then it must be served upon that. Then, my lord, subsection then subsection 3 is prescribed.
An order under section 3(1) has passed.
Passed.
Let us assume that thereafter, after passing that order, the government may decide, no, I may not need that. It has actual 12 acres. Now, for the purpose, it is required 10 acres.
Yes.
So a fresh order modifying that 3-1 is to be passed,
Yes, certainly.
has to be passed. Then the government may decide, yes, to enforce delivery of possession with regard to 10 acres.
Yes. But
But
it
if
if
that order is not
never
modified,
modified,
so-
government cannot. Government
so
cannot go behind or under subsection.
the government has a right to enforce that order
Yes.
and to take possession.
Yes.
Can the government, if the government fails to enforce delivery in terms of 3-1,
Yes.
can the government come up and say, no possession was not received from you?
No, it can't be. That is not the scheme of this section. That is not within this scope of section 3.1. Why I am saying this? Because I am telling you a lot.
Then you are,
Suppose certain person I am in occupation. Certain person is occupation of the tenant. Now, after order of requisition is passed, entire requisition order of in respect of entire land was served upon me. Then you, after going into the land, you cannot say a portion of the land is in occupation of the tenant. So I am taking possession of the land, keeping Lord the occupation of the land under the tenant, leaving aside the land occupation under. That cannot be done because there is specific procedure under subsection 3, under subsection 3 of section 3, how possession is to be taken. And it is not only that, then there I join the issue, to your lordship, the order, the preliminary report, they submitted, submitted before your lordship, I will come to that. They say in the later part, some portion of the land is in occupation of refugee, etc., like that. But in spite of that, it was decided by the government intends to requisition 12.46 crore. Kindly come to government record.
all right, before that you wanted to show section 4 also. You can make submissions on that, thereafter we can go on.
Section 4.1a.
You wanted to place section 4 also.
4.1a, I do not want to see.
All right.
4.1a is not necessary. That relates to vesting. That can be, the vesting will relates to the portion of the land which is covered by 4.1. Acquisition and covered by 4.1a, which is beyond, which is not within the 4.1a, that will not vest in this case. I have no
they may not have acquired,
but
requisition is
yes,
there.
requisition is continuing. And enforcement shall be done by special procedure prescribed in section 3. They cannot come to say, after going to this plot of land, that somebody is occupying, so I am not taking possession. And at least no notice has been served upon see, come to see. They simply served a notice of requisition intending to take.
To have a glass of water.
From yesterday, I am.
You can.
No, I know, right.
You can ask your juniors because.
So, my lord, two parts of section 3. First of all, order.
Then enforcement.
Then, my lord, then
enforcement of that order.
Enforcement of the order by special procedure by magistrate.
As laid down in subsection 3.
And so, it is clear from the act, clear from this section, that entire land of the owner, belonging to the owner, may not be in possession of his possession. It may be in possession of third party by occupier. In that case, land notice shall be served upon the occupier. This is the scope of section. Now, more in this background, kindly come to the government's documents. Preliminary report. Or a third page.
This is that bunch of document which starts with the order dated 1st of June 2023.
Yes. This is government reconstructed record.
Yes.
Kindly come to 4.
Page 4.
Item number 4, page 3, item number 4.
Page 3, 1. Yes.
Total area of land proposed to be acquired, 12.48 acres as per ROR. 12.48 acres as per ROR comes to 12.48 12 point something is not listed, but an area of 0.8 acres is vested, which will not be requisition. Thus, the order of requisition comes to 12.46. This is the final decision after preliminary inquiry report. And after that, some observation are there. Some families are etc. are occupying. So, fully knowing that some third parties are occupying the portion of the land, they issued the order of requisition in respect of 12.46 acres. And then we will kindly come to the order under requisition, last 2 pages. Last 2 pages of this bunch.
Yes.
In exercise, I have to place the order described in the schedule, the disposal of the surveyor, 3B Rai, etc. on 30th May 79 at 12 noon, etc. So, my lord, so far as Act 1 is concerned, your lordships knows that there are, so far as scheme of Act 1 is concerned, it starts with 4 certain paraphernalia, objection, declaration, then award. After declaration of award, they can take possession under section 16. And in that case, separate notice under section 16 is to be served upon the landowner. But here, there is no, even under the scheme of section 3, only the order under subsection 3.2 is to be served. So there is no separate provision to take possession or regarding service of notice. So service of notice and
Order, thereafter enforcement.
So it's a combined notice of requisition along with taking over of possession. And that is clearly reflected in the order under section 3.1. Then we will kindly come to next page. Here, plots are mentioned.
What numbers have been mentioned and the total area has also been mentioned as 12.46.
Now, what we are the requiring, now they want to take reliance upon the documents of the requiring body. Requiring body, I mean, only one document. Because their documents, the requiring body has some some document. Page 3. Page 3 of the government the possession certificate. As your lordships got it. Page 3 of the requiring body has filed some document. This is the bunch of documents. Possession certificate.
In fact, on 5th of September 2024, my lord, as per your lordship's direction, my lord, I have filed those possession certificate.
That is 4th page.
Is it this order which starts with the certificate of possession of property made over?
Yes.
Yes, my lord.
4th page. Yes.
Certified that I have this day, 30th May 2079 at 12 noon, received possession of the property at the hands of T.I. LS Surveyor. His name is mentioned in the order of more or less 10.64 acres comprising RS code number assigned. Now, my lord, kindly see the bottom endorsement is there. After demarcation, vacant possession taken over by premises, taken over 10.34%.
So the requiring body has taken a lesser part.
But I am not saying, I am disputing this. Order under requisition speaks of 12.46.
Or in other words, this cannot nullify an order of requisition.
Yes, it cannot. Government cannot say that I have taken possession of 10.43 and according to the request, I must say not requirement, they say they have taken possession of vacant land measuring 10.34 acres, so requisition order is modified.
Mr. Bera, where is the provision for release from requisition?
Section, I think section 6 or 5. Section 5, 6 possibly. Sorry, section 6, yes, section 6. Lease from liquid.
So
Under section 6,
thereafter 4(1)(a) was issued.
yes,
4(1)(a) was for 10 point something.
yes,
So that was acquired.
yes, acquired.
So in view of section 6, if they do not, if the balance portion, they have to take recourse to section 6.
They have not. They have not. Now, my lord, even assuming, according to them, it is occupied by some third party. Immediately, it could have been, my lord, the release from requisition. We could have legal steps against them, intruder. Now, till 79, we are in 2024. Till today, the order of requisition is valid. Simply saying, then again, this kindly see, this requisition order, this possession certificate is not countersigned by the landlord. They did not know anything about this.
Vera, can the requisition continue after repealing of Act 2?
No. No.
So at best it could have been till that date.
Till that day. But we as a landowner, we cannot say that the government is not in possession of the land. Entire proceeding for requisition or acquisition, whatever it may be, that stood lapse on 31st March 1997.
Yes.
According to position of law. These men, my lord, they did not think it fit to release the land for people. They are, in many cases, we had to approach before your lordship's completion of our acquisition or to pay compensation, where the government remained to be in possession of the land after 31st March 1997. In many cases, the government had utilized the property permanently.
So according to you, the government is in symbolic possession of that balance
Yes,
portion.
symbolic possession of that. So particularly, my lord, because in view of specific provision of section 3, that it is not necessary the entire land shall be remained in possession with the landowner when the possession is certificated.
Yes.
It can be in third party. You enforce the order against the third party according to procedure prescribed under the Act. Now you cannot say. Most interestingly, they have never said to us that, please see, we do not want to, my lord, take possession of the entire land. And not only that, I have shown to your lordship the inquiry report. Inquiry report specifically says that occupation of some third party, but they said that it is under the requisition shall be made in respect of 12.46 acres. So then they ought to have taken.
So where they have said that in the preliminary report that it is in the possession of third party.
No. Preliminary report is also it is a formation of opinion.
Yes. Where in the preliminary report it has been said that it is in the possession of third parties.
Yes, that is there. That is in the inquiry that the kindly come to
the report of the state.
Report of the state, order sheet, reconstructed record.
Yes, yes.
Your lordship says 4 I have seen. Order
yes,
of
4 you have shown.
Yes. Then mirror 6. The number of families 31, 32, 31 on the southern portion marked by Bhara. The item number 6, 7 is there, or occupier who are all occupying the since 72, 73 according to them. Kindly read.
Occupy, who are all occupying.
So, order of requisition cannot be said to be invalid because that is being occupied by some third party.
Likely to be displaced.
Yes. Displace them if it is a requisition order. Everybody is bound by the government order. Everybody.
Subsequently.
Preliminary inquiry report cannot be after cannot be issued after the order of requisition was passed. They have not said. when this was done. According to the affidavit they have done before that.
Yes,
So by virtue of this possession certificate, they wanted to disclose before your lordship wanted to say that entire order of requisition has not been implemented. Rather, part has
that
been
document may go to show what was handed over to the requiring body.
yes, that is the at best it can be concluded that. But requisition order is not, by virtue of this possession certificate, requisition order cannot be null.
Or whether it can have the effect of amending the section 3(1) order.
Cannot be done. But my humble submission, whatever steps are required to be done, that should be done. At best, they could have, after preliminary inquiry, even after
Passing a revised order.
yes, because 12.46, they went to the spot, they found it is not necessary. Even according to ESI, it is not necessary. 10.3.
A revised order under section 3(1).
A fresh order under section 3 ought to have been done. By
Yes.
showing documents, they cannot say that the order of requisition became invalid or like that cannot be. So my submission is there must be deemed to be in symbolic position of the balance land, and they have to release. If they want to release, they have to pay compensation for this. I cannot utilize the land because of this order of requisition. That shall be deemed to be. So they must pay requisition compensation and release the land.
Anything more you want to submit?
No, nothing more.
Yes.
But that is my submission. Either release or to acquire it, in accordance with law. Then, my lord, this procedure, your lordship, under 2013, there is no other way. If you want to acquire it.
Government leaders, my lord, that in this matter, my lord, senior government advocate Mr. Galib will argue, my
You
lord.
are trying to show some documents. You start, Mr. Galib will join you. Yes.
He's probably addressing in another court, my lord.
Yes, yes. Right. Let me ask Mr. Yes, Mr. Mitro, what is your submission?
This is, my lord, with regard to the fact that, my lord, the quantum of the land that has been, my lord, handed over to, my lord, the requiring body is apparent on the face of the document, which, my lord, I have submitted my lord, in pursuance to your lordship's direction, which
Yes.
shows, my lord, 10.34 acres of land has been, my lord, actually handed over to the requiring body. So, my lord, with regard to this fact, my lord, as it appearing from the face of this document, I cannot, my lord, really improve or, my lord, modify anything, because this is, my lord, apparent on the face of this. This is, my lord, the amount of the land, my lord, which has been, my lord, handed over to us for the purpose of construction of a hospital, my lord.
Yes. Yes. Yes, Mr. Meena.
2.12 acres of land is always under dispute, my lord. It was under the, my lord, some squatters were, my lord, sitting over
Sir,
there for a
Meena,
quite
one-
long time, my lord.
one-
I forgot, just because they have not come up with any document that they want. Notice was served upon us to take possession from us. No steps was taken. I do not know what they have done.
Mr. Meena, one legal issue. Admittedly, an order under section 3(1) was passed
Well.
for requisitioning land measuring about 12.46 or 48
Well.
acres or so.
Well.
According to you, or there are documents to show that 10. 46 or something,
34, 10.34.
34 has been handed over to the requiring body. 418 was issued with regard to or in respect of 10.34. So, what is the effect of the balance land? That is the issue to be considered. Acquired 10 point, there is no dispute on this. Acquisition is with regard to 10.34. Act 2 permits a lesser area to be acquired. So now the point is, what is the effect of this balance 2.12 or something acres? Is it under requisition? Was it not requisitioned? Was it released from requisition? Or it's still under requisition? You have to explain that. Because admittedly, there is an order under section 3.1. Do you have a copy of Act 2? Place section 3.1.
If the state government is of the opinion that it is necessary so to do for maintaining supplies and service essential to the life of the
Because
community.
keep the remaining, those are the purposes. Next, kindly come to the state government may by an order. Last part of that. Last 3 lines, the state government may.
The state government may by order in writing requisition any land and may make such further order as appears to be necessary for expedient in connection with the requisition.
So an order is to be passed. After considering the purpose, an order is to be passed. Here, admittedly, an order under 3.1 was passed for 12.48 or something, 46, for 46. Next, come to subsection 2. That order shall be served. Let us skip that. Next 3. So this order is executable. They are bound to the person upon whom the notice is served or against whom an order is passed. He is obliged under Act 2, subsection 3 of section 3 to comply with that order. If he fails to comply, then recourses are available under clause A and clause B of subsection 3 of section 3. Next is section 4, is acquisition. Acquisition admittedly of 10.34, requisition of 12.46. So, what is the effect of that balance? You have to make submissions on that. Facts are all admitted. Possession giving to the requiring body is 10.34. Requisition order 12.46. Acquisition 10.34. Balance is 2.12. What is the effect of this land?
Is to be deemed released, my lord, till the end.
Where is the provision for deemed release?
There is no provision in the act itself.
Then there is some indication in the documents which you have handed up. But there is also a missing link. You have to provide that missing link.
But kindly permit me to come back, my lord, with the instruction, my lord.
Instructions will not help you. This is the point of law. What instructions? Instructions documents you have produced. Instructions will not help you. They cannot, because these are the reconstructed records. You cannot produce any further records. These three parts are admitted. Initial 3-1 order of 12.46. Then
But,
possession handed over to the requiring bodies 10.34. Acquisition of 10. These are not in dispute at all. Mr. Bera is also not disputing. None of you are disputing this. Now there remains a balance of 2.12. What is the effect of that land?
Regarding deemed release,
Whether Mr. Bera's client is the owner or you have taken the possession. Possession is with
we have
Mr.
not-
Bera's client through someone or it is by someone through you.
someone through me is not in possession, my lord. All along they are in possession, my lord. Regarding
Who are in possession?
his quarters, my lord.
So
We
Mr.
have
Bera's client is also not in possession. Not in possession. So, but you have issued an order of for the entire area. Since you have issued an order, you have to take responsibility for that.
But whether
You have to proceed in accordance with law. If you have found no possession could not have been taken, there are recourses available under this statute. What prevented you from taking that? If you have not taken those recourses, then consequences will follow as per the statute.
regarding deemed release, my lord, kindly permit me to come back, my lord. Regarding
When
deemed release.
Mr. Galib will be available? 2 p.m. there is another matter fixed. After that, this.
Another matter is fixed.
Another matter thereafter. It will not take much time. Thereafter, Mr. Bera, you are in difficulty.
No problem. I will come at 2 p.m.
It's a short issue. Tell Mr. Galib this is the short issue for which.
I shall come.
What is the effect of 2.12?
Seventeen.
Item number 17. My lord, item number 17 and 18. Answer model for the state. Answer model for.
Mr. Mitro, it will be taken up at 30 minutes.
My lord, I am praying not today. He
Not
could
today.
not come today. My lord, Answer model could not come today. He is for the state.
Who has not come?
Answer Mondal, Answer Ali Mondal. My lord, he is 73 years old and he is some difficulty, so he could not come today.
73 years old.
He
could not
his-
come.
His back was broken. His backbone was broken. He was hospitalized. After that, he was.
Tell him that you have told me this fact.
No.
Tell him that you have communicated this fact to the court. And what will be his answer to you?
He could not come today, my lord.
Why?
For due to his illness?
Illness?
Yes, my lord.
When he fell ill?
No. His total body was.
When he fell ill?
No, my lord. His backbone was broken. He was 2 months. He could not come to.
Is he not coming out of his home?
No, my lord.
He's not coming out of his home.
No.
Are you sure?
He could not come today.
I'm not talking about today.
No.
Are you sure he is not coming out of his home?
No.
Tell him that you have communicated this fact to the court. Then what will be his answer? He will get that. That now he is not coming out of his home.
After the vacation, he could not come to the court. After the vacation.
I am asking you, has he not come out of his home? I am not asking you, has he not come to the
Yes, my
court?
lord. He said that he could not. Today he was not.
Yes, Mr. Kundu.
Lordship is putting a very. Now the problem is not your lordship is not sitting on a regular basis. That is the problem with this matter, my lord. Two matters in which, my lord.
What is the issue?
Your lordship. Give me some 2 minutes time.
Mr. Mondal is being assisted by someone. Who is assisting him?
I don't know, my lord. I am led by Mr. Ansar Mondol.
দেখি রেকর্ডটা দেখি। Yes, Mr. Alam is assisting him.
Yes.
Where is he?
My learned junior so to calling over telephone. He's not there. He's not picking up the phone as well. But there was an earlier writ petition filed way back in 2006.
What is the issue, Mr. Kundu?
Yes, madam. Land was required and under the
This is also another acquisition matter.
Yes. And for these are old matters of 2012. That was at a point of time when I was unwell. At that point of time, the land was sought to be acquired, and then no award paid, no money paid, nothing whatsoever. We filed a writ petition in 2006. At that point of time, Justice Jointo Mishra's passed an order that parties will have to be served with the award and the award and also notices under sections 12 and 13. State was represented by Mr. Shidaram Samantu. It was not even stated.
You have paid for setting aside of the award.
No, no.
That is your prayer.
Yes. Now, my lord, in 2012, for the first time, they come up with the plea that award has already been passed in 1997. Without even telling this fact for the last 15 years.
All right, so
and on the day we were given a notice
Mr.
under
Kundu,
section 11.
the state has filed an affidavit in opposition. Have you filed your reply?
Yes, yes. Everything is.
Today you are filing.
Yes, yes.
Affidavit in reply filed in court today is
Two matters, 18 and 17 and 18.
both the matters you are filing the reply. Same matter.
Yes.
Same matter.
Two parties. One is
But
a company
issue
and
is
one.
the same.
Yes.
17 and 18 আলাদা order হবে. Affidavit in opposition, affidavit in reply filed by the petitioners is taken on record. An accommodation has been paid for on the ground of Mr. Ansar Mondol, learned advocate representing the state. Yes, when do you want?
Day after tomorrow, my lord. Day after tomorrow.
Day after tomorrow.
Your Lordship kindly inquire from him whether Mr. Ansar Mondol is coming out of his house.
No. It is confirmed, my lord. He could not.
It is confirmed that he's coming or he's not coming.
He's not coming. He could not.
Tell him this fact that you have submitted that he is not coming out of his home.
No, my lord. He called me. His body. He was ill today.
An accommodation has been paid for on the ground of Mr. Ansar Mondol, learned advocate for the state. Pustup as paid for by the learned advocate for the state. List this matter in the next week.
No, we shall give notice to the other side also. We shall give notice to Mr. Mondol Jr. also.
You will serve a notice.
We will serve a notice.
The learned advocate on record of the petitioner is
Mr. Rosu
will be at liberty to intimate the next date of hearing to the learned advocate appearing for the state.
The Lordship is fixing a particular date, my lord.
That is the most difficult thing so far as.
Your Lordship,
Next week I have kept it, give a notice. Let us.
Much obliged.
Same position.
Same position it will retain.
Much obliged.
Yes.
19.
Lordship, I beg to appear on behalf of the petitioner. It is, my lord, the Bidhannagar Municipal Corporation. An additional tower had been constructed, my lord.
Yes, Mr.
And-
Nag.
We had submitted a report, my lord.
My lord, the report we have taken exception. My lord, Lordship
What
was
is the report? What does the report say?
the report. I am reading, my lord.
No, any deviation, anything?
No, my lord, report, my lord, is
Nothing mentioned, my lord. Though there are deviation, everything is there. Additional floors are there.
Accept the copy of the exception, my lord, because he has annexed the report, my lord. That will be
In
easy.
the exception, he has annexed the report. Exceptions টা কোথায় আছে?
Not homeless, my lord. Last occasion also I appeared, my lord.
for the flat owners.
You are for the
Flat owners.
flat owners.
He made an application for addition of part of the flat owners. Can pay.
This is Mr. Chakraborty affidavit in connection with the report.
Report.
That is the exception.
Yes, madam.
Yes.
Lord,
Where
page
is the report?
41.
First show me the
Page
report.
41.
Page 41.
Lord.
Seen affidavit.
There is affidavit of the petitioner taking exception to the
No, no, no,
inspection
no.
report dated
ওইটাই।
4th September.
বাবা, এত মোটা?
It is a 42-page affidavit.
Page. But I'm placing.
Kuma, আমার পেজটা
আমি দিচ্ছি বলছে পেজ 41 লর্ডশিপ উইল ফাইন্ড দিচ্ছি আমার খুঁজে পাচ্ছি না দেখেন তো রিপোর্টটা পান কিনা 24 এর এটা but in connection with the WPA number so and so my lord now the direction was issued thereafter my lord, there exists 6 block in the housing block A B C yes my lord existing block my lord housing block A B C are G+5 storage structure and block D, E, F and are G+5 storage structure, 4-story structure. From record, the building plan issue registered is found that the building plan number so and so 9/3/2004 was first sanctioned, provisionally sanctioned for G+4 storage structure by the then Rajarhat Gopalpur municipality.
Yes,
Then my
Mr.
lord,
Nag, how can you say that later the plan was revised by the Rajarhat?
yes, my lord, where is the authority, where is the law? The only
Show
question.
me that it was revised. How can you say that it was revised by the Rajarhat Gopalpur municipality? Show me the document.
The difficulty for the Bidhannagar Municipal Corporation is after merger, my lord, this is only what we have from the record.
Why did you say this? Can you say that it was revised?
No, my lord. Whether the revision is right or wrong, my lord, we are not on that.
No, 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 no. I'm not on revision is right and wrong.
Lord.
How could you say that there was a revision? Do you have any documents to show that there was revision?
Lord.
Thereafter, the court will consider whether it was right or wrong. Show me a document that there was a revision.
I have to come back supporting that document. my
No,
lord, because
you have said
my lord,
the
will
letter
only
was
one-
revised.
My lord, will only recollect one thing. This matter was first, my lord, directed by your lordships to have a fresh inspection. When we went ahead for a fresh inspection, my lord, the flat owners did not produce any documents. Thereafter, my lord, directed, then the flat owners submitted the document. So document is there.
Not there.
They only supplied
Did
the revised.
you have the, have you got the plan?
Revised plan.
Revised
যেটা
plan.
জমা দিয়েছে আমাদের। My lord, they only provided us with
They
the
have
revised.
provided you the revised plan.
That is what they had provided. My lord, that is what my verbal instruction is, my lord. However, I should not travel beyond the inspection report. But if there is a document, my lord, there has to be a document or else the officers would not have written so. But I remember, my lord, it was clearly even on the last occasion submitted that this plan was submitted before the
We have
officers.
submitted on 14th August 2024 first lordship directions. Yes. We have produced it. The papers. 14th August 2024.
দেখো তো 17th February 2012 কোনো প্ল্যান আছে কিনা তোমার কাছে? 17 December.
Sure, that's it.
3rd March. Sorry, 17 December. But the 17 December 2012 plan is with my learned city.
Sir, do you have a copy of the sanction plan for G+5 storage building?
This is the plan, my lord,
Show it to Mr. Chakraborty.
we have relied upon.
Show it to Mr. Chakraborty.
kindly see my lord, I have already seen this thing. Here as it written my lord, plan dated 9/3/2004.
My lord.
CC 435/12 of 2013, sanction dated 17/12/2012, approved by the chairman Rajarpur Gopalhat municipality. Lordship, one thing lordship very well known, this is the board of councillor who is the appropriate authority, But here it was approved, my lord, by the then chairman.
Chakraborty, there are two things. One is whether there was approval or not.
My lord, approval cannot do, my lord. Beyond the power, nothing is there in the the West Bengal building.
No, is it for G+5? Have you
No,
seen that?
initially
Initially it was
plus
G+4.
4. And
Yes.
then, my lord, subsequently, completion certificate they have obtained from the appropriate authority.
Completion
that is-
certificate has been, no, the plan for
Yes.
G+5.
Yes,
Is
my lord.
it the plan for G+5 which has been approved by the chairman?
This is a G+5 plan.
Yes.
It is
My lord-
written, my lord, completion plan of G+4 and G+5 storage residential building, CS tag number so and so.
I will just address, my lord,
Our humble submission,
till 5th floor. B is 5th floor. C is
also 5th floor.
my lord, only D is 4th floor. E is 4th floor. F is again 5th floor, and swimming pool, and that is different.
Now, my lord, the
This is the
question,
final plan which they had provided to us
Yes, ma'am.
after my lord had directed for inspection. Because my lord, earlier occasion, we had filed another report. There we did not say this because this was not with us. And then we matched it, my lord. It is matching. It is not that it is a forged plan or something, my lord. Because whenever there was a forged plan, we have gone ahead and filed FIRs. Whenever we have found that the details of the plan is not matching the register after we have got the numbers and all, we have filed FIR, but here in this case, we did not find that. So no criminal proceedings was initiated against the persons who produced the plan. And now, my lord, if Mr. Chakraborty is aggrieved with this plan, my lord, humbly, my lord, perhaps this plan has to be challenged
no, you have challenged it.
separately.
We have
Perhaps.
challenged it by way of amendment. I'm showing, my lord. I'm showing, my lord. Kindly come to my lord, kindly come to my lord, the writ application. And there was a direction to the municipal authority to file, my lord, taking into consideration all the paragraphs we have stated in the amended petition. Lordship, kindly come to my lord. And
now,
prayer also.
now, Mr. Chakraborty, there
Yes.
are two things.
Lordship.
Your initial writ petition was that this construction was without any sanction.
True.
Now they have produced documents that the erstwhile Rajarat Gopalpur municipality, that initially the plan was for G+4, then G+5, plan was also approved, completion certificate has also been issued.
But there was,
Now you have to challenge
but we
the
have,
sanction.
but
So you challenge the separate
I'm
proceeding.
making submission for a minute, my lord. My lord, meanwhile, I have got by way of RTI, pursuant to the direction issued by this honorable court, this plan which they are showing to us. Immediately file one amended application before the honorable court. Honorable court allowed that amendment application. Lordship will find from page 37 onwards of the writ application. And Lordship, kindly see the prayer. The prayer may kindly be shown. All are incorporated. We are challenging it now. Lordship, kindly first, my lord, kindly see.
The amended writ petition.
Yes, my lord, kindly see page 37 first.
Page 37. Yes. Yes, 37.
37, my lord, 22 EU. Lordship got it?
Yes.
Now, my lord, we have, my lord, a comparative table is there. And the deviation and, my lord, the unauthorized construction, everything we have narrated. 20, 37, 38, 39, 40, 41. Then, my lord, I'm turning, my lord, kindly turn to, my lord, the prayer of us. That is page 57. 56, my lord. 56. Lordship will find para 1, a writ of and in the nature of mandamus commanding the respondent on each one of them, their main agent and assigned to recall, cancel, revoke, or set aside in accordance with the provision of the statute, impugned, revised, or completion plan, so and so, dated 17/12/2012. Initially, plan was sanctioned in the year 2004, and then, my lord, the revision was taken place without any power, and occupancy certificate issued.
There are separate aspects. You have prayed for cancellation of the initial plan also.
No.
What is the?
No, my lord, kindly see, we are asking for revised plan, cancellation of revised plan.
Only the revised?
Yes, my lord. Because we are there up to 4th floor, no problem, my lord. We are not raising any question. Apart from that, and thereafter, after this amendment,
the ground for challenging this
Lord, we will kindly see the next prayer as well.
Paying for setting aside.
Yes, my lord.
What is the
I'm coming.
ground for
I'm
paying
coming.
for setting aside?
I'm coming. Without power, my lord. I'm coming. Definitely without power. I'm coming.
Show me the ground.
Lordship, kindly come to page 47. Then, my lord, kindly come to, my lord,
47.
Yes, my lord.
Page 47, yes.
Page 47. But kindly come to my lord, Roman 6, page 48. For the developer has obtained approval from the municipal authorities as alleged by him. The aforesaid sanction plan has been obtained by means of misrepresentation and fraudulently wrong statement. Acts as a municipal authority are required to revoke, cancel the same immediately upon revocation of the same. Any building or any work commenced, erected, executed should be deemed to have been commenced. So and so. Then, my lord, that 49. That the inaction or non-action on the part of the respondent authority amounts to failure or discharge of statutory duties.
Mr. Chakravarti,
Lordship.
did you make a representation before the municipal authorities for revoking the sanction plan on the ground of misrepresentation and or fraudulent
No,
statement?
my lord, the matter was pending since 2012. Meanwhile,
Mr. Chakravarti, this is an issue of fact.
Lordship.
Fraudulent misrepresentation, fraudulent statements, this is a factual part.
Kindly,
So you have to make a representation. They have to take a decision on that.
kindly see, my lord.
Now, Mr. Chakravarti, your initial writ petition, kindly consider this.
Lordship.
Your initial writ petition was that some construction was without sanction.
True.
Now, they have come out with some documents to show, no, initially there was a G+4 story construction which was approved. Subsequently, it was approved to G+5.
Lordship.
Now, you have paid for cancelling or revocation of that revised plan on the ground of suppression or misrepresentation. So you have to make out your case. You have to make a representation to them.
True,
They have to take a decision. This court cannot decide on
my
that.
lord, they have passed order, my lord. My lord, order in the form of affidavit pursuant to the direction issued by this honorable court. They have filed it. I'm coming, my lord.
On misrepresentation.
Yes, my lord. Kindly see, my lord.
Where is that order?
My lord, I'm kindly come to my lord 7/8/2018 order of this honorable court.
Show me their order passed on.
No, my lord, this honorable court, after this amendment of writ application, my lord, directed them, my lord, to deal with all this paragraph where we have made this our new case, my lord, to deal with that particular issues, directed to file, my lord, their affidavit. They have filed their affidavit. I'm showing that affidavit also.
Show me.
Prior to that, my lord,
show me your case dealing with misrepresentation.
My lord,
what are the misrepresentations?
No, only not, my lord, this is only not misrepresentation. At the same time, this is beyond power, my lord. In the four corner of the Municipal Act, there is no such provision of, my lord, revising in this fashion. My lord, the post facto regularization, pursuant, my lord, and my lord, the payment of, my lord, retention charges is not, my lord, aligned, my lord, so far the West Bengal Municipal Act is concerned. I will show, my lord.
By taking retention charges.
Yes, my lord, they have taken. I'll show, my lord. Kindly see the writ application. They have taken retention charges.
Retention charges.
Yes, I'm showing.
At that point of time, my lord, factually,
True,
I
my
am
lord.
not equipped to assist.
Mr. Chakravarti, show me the
retention.
It was approved by taking post facto approval by taking
Page 66, my lord.
Of the amended writ petition.
Yes. My lord, they stepped into the, my lord, that particular municipality merged with them. They are not taking responsibility of that municipality. Everything is with them.
It is
Factual action.
not that.
Page
Only
66, my lord.
Page 66.
Yes, my lord. This is the resolution. Then lordship turn to.
Give me a minute.
Page 120. Page 121.
This is for getting documents.
Page 121, my lord. I'm sorry.
121.
Yes.
121.
Amended.
Amended.
121, yes.
This resolution, lordship will find, my lord, page 129. My lord, K, Kh, G, Gh, Unga, Ch, Ch, Gijja. 129.
Yes.
CC file number 435, completion. My lord, 435 of 12 of 2013, 50% মুকুব করার সিদ্ধান্ত গৃহীত হলো। The CC, my lord, which they have shown just now, that particular number is there also, and it has been reduced 50%. Lordship will find, my lord, page 18, paragraph 21 may kindly be looked into of the writ application. Page 18 may kindly be looked into, my lord.
CC file number 435 is with regard to your premises.
Yes. And my lord, that top floor has been regularized by initiating this particular file 435/12 of 2013,
yes,
dated 17/12/2012, is purportedly issued, my lord, page 18 is issued in favor of the private respondent is annexure to and marked to the annexure P6. And there was a direction, my lord, by this honorable court to deal with all this paragraph in an appropriate manner. My lord, without dealing, they have avoided all this question and file a, my lord, one affidavit which fails to answer any of the question raised by this honorable court. The protracted litigation, my lord, since 2014. Lordship will find, my lord, some other document also.
This resolution is of 2012.
Yes. And thereafter, my lord, this completion certificate has been issued. Even, my lord, they are, my lord, so, my lord, gracious, my lord, they are, my lord, magnanimity is also there. My lord, to, my lord, allow them 50% reduction. I want to put this question to myself, where the provision is. Whether the four corner of the Municipal Act, such provision is there. My lord, if the provision is there, then, my lord, I may be, my lord, that particular, my lord, regularization may be possible, my lord.
You have implemented all the flat owners.
Yes. Yeah, implemented, my lord. The only thing, my lord, on implement application is pending before this honorable court. On that particular date, lordship directed municipal authority to go there, notice, so that they may come.
Yes.
Lordship was at the opinion, my lord, it is redundant at this stage. They will go there and they will make their submission. That being the situation, they went there. They were there. And at the same time, we have
for that. Instead of, kindly consider the, instead of impeded, they have to be impeded.
Yes, my
They
lord.
have to be hard.
Yes, my lord.
Because they have purchased a flat in those.
Yes, my lord. We have no objection.
Instead of that, because these are all facts.
Yes.
So you make a comprehensive representation with regard to this. I will direct them to take a decision. You can place all these documents upon hearing.
No, my lord, they have taken a decision, my lord. They have, the report says everything is okay. No problem is there.
That report, I will direct them to revisit. You have to make a, because your prayer is for revoking.
Not only revoking, my lord.
Yes. Of the sanction plan, you make a, I will give you liberty to make a comprehensive representation. They will take a decision upon giving an opportunity of hearing to you, to all the parties.
No, our application is pending over here, my lord. 2014 onwards, this is, my lord, pending.
I appreciate that. But Mr. Chakraborty, these are all factual aspects. Fraudulent statement and other things, all these documents are not on record. All these you can produce there. You can make out that case.
Our humble submission, my lord, before this honorable court, my lord, protracted litigation 2014, contempt jurisdiction evoked, and my lord, punishment was given to the contemptor. They have transferred, my lord, one flat during the pendency of the matter, and my lord, now we have amended it.
Mr. Chakraborty, contempt is one thing.
Yes.
First is whether the constructions made as per the revised plan that should remain or it should be demolished.
And the same time, my lord,
that is the primary concern.
The question whether this particular provision is within the statute book or not, that is also to be decided by this honorable court.
Which provision is?
My lord, the provision of regularization in lieu of, my lord, the retention charges.
Mr. Chakraborty, you are going to the next step.
Yes, my lord.
If the regularization is a different thing, according to them, they have revised the plan. So there you can question everything, that they cannot
no power, my lord,
give post facto approval upon taking the retention fees. Raise that point, they will decide this and pass an order.
My lord, keeping pending this application of this honorable court direct us, that is, my lord, well and good. Unless it is pending, my lord.
If an order is passed, you have to challenge that.
No, my lord, 2014, my lord, 2014 onwards, I am in the court.
I appreciate that.
Lordship.
But you have to challenge that order again by filing a supplementary.
That is why, my lord.
By filing a supplementary affidavit.
Yes,
or
my
by
lord. Yes,
way of
my lord.
amending.
Yes, my lord. Yes, my lord.
It's better to file a fresh writ petition challenging
no,
that.
My lord, kindly see, my lord. Kindly see, my lord. We are fighting for one.
You want to
my lord, last 10 years. My application is there, my lord.
I only gave a suggestion.
No, my lord, subject
for you to accept or not.
My lord, subject to correction, my lord. My application for including all those flat owner to be party, kindly allow that.
They will be added.
Kindly allow that. And then, my lord, a date may kindly be fixed. We will come back in presence of them.
File affidavits with regard.
Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord.
There is only one.
Where is your application for
the application possibly 12, my lord.
Technical problem is, my lord. Now, with the application of adding the other flat owners as a party, my lord, the petitioner has accepted that they were at all point of time necessary parties. Now, my lord, he has filed a writ petition. Thereafter, he went ahead and filed an amendment application, which he very well thoughtfully decided to get it approved by the court in their absence.
Certainly not, my lord. There was newspaper advertisement.
Follow your sir.
There was newspaper advertisement also.
Flat owners also have the right of giving an opposition to the amendment application made by them.
Non-joiner of parties, my lord, making.
It has already been allowed.
But that is what I am saying, my lord. Now,
There is a
Here,
application for recalling of.
my lord, the only thing,
that is what
Recalling is the,
that is the scenario. If a new writ petition is not filed, then the entire case made out and changed
that risk
in
is
time.
taking.
no, my lord, kindly see, 2014, I am doing this matter. My lord, there was newspaper advertisement to be the party.
Where is your application for amendment?
My lord, the application, lordship, my lord.
And we are there.
And there was no requirement of a newspaper publication.
Well, I can 12 of 2023. My lord, my learned friend recently entered into this particular matter.
Can
12 of 2023, my lord, in all probability, my lord. 12 of 2023. Once I have moved this application, lordship was kind enough to observe. At this stage, it is not needed.
Look, I do not mind, my lord, if they are added as a party and they defend the cause, how they have got into the plans, my lord. However, my lord, the builders also have to be added as a party, my lord,
Yes.
because it was the builders who obtained the plan from the
Builder is
municipal.
party. You are not in a
No,
position.
no, they have to be given a notice. Because
Builder is party, my lord.
my lord,
builder is the party.
Party.
builder is the particular person concerned who will be able
I-
to assist the court in the legality of obtaining the plan.
Builder is party very much. Substitution is also taken place. You are not aware. Number of matters are with you. Ashte na tamade party na.
Getting all the documents from the developers.
Developer is very much party, and my lord, diet and substitution is also taken place.
We have no fault at all.
Lordship allowed substitution.
What is our,
These are the flat owners of the
Yes,
fifth floor.
yes.
Ashwin.
what is our fault, my lord? We have got the all papers,
The
everything.
petitioners,
बोले ना हम थोड़ी नीचे है पूरी हो जाएगा
the writ petitioners the petitioner has filed this application praying for
with the leave, may I, my lord?
addition of, kindly wait, because there is something,
Deep.
praying for addition of the owners, addition of the flat owners of the fifth floor in respect of blocks A, B, and C of the building in question, of the complex,
Of the complex.
of the complex,
Shreya residency.
of the complex, namely Shreya residence. The writ petitioner has paid for cancellation and a revocation of the revised sanction plan and the completion plan.
Completion.
And the completion plan.
Revised plan, my lord, for one top, my lord, the provision.
Initially, a G+4 storied construction was made, and thereafter an additional story, that is the fifth floor, was constructed. The petitioner alleges that the said construction is an illegal one. The petitioner further alleges that the proposed that the flat owners of the fifth floor of blocks A, B, and C are necessary parties in this writ petition. Paragraph. Heard Mr. Chakraborty, learned advocate, in support of this application, and Mr. Nag, learned advocate for the Vidhannagar Municipal Corporation, and Mr. Rai for the proposed
Added
parties to be added in this writ petition. First up, after hearing the learned advocates for the respective parties and considering the scope of this writ petition, this court is of the considered view that the flat owners of the fifth floor of block A, B, and C are necessary parties in this writ petition. First up, accordingly, where have you? There are particulars. Where have you? Yes. Accordingly, the where have you mentioned the particulars of those proposed?
My lord, there.
Anindo Rai, Tapan Kumar Das.
Yes, my lord.
Accordingly, the persons who have been impleaded as proposed added respondents, as mentioned in the cost title of the application for addition of party, be added as respondents to this writ petition. First up, the department is directed to carry out the necessary amendments within a period of 2 weeks from date. First up, paragraph. The learned advocate on record of the petitioner is directed to serve a copy of the writ petition, amended writ petition with the amended cost title upon, you have instructions to represent all of them, upon Mr. Rai, learned advocate, who has instructions to appear for the added respondent.
Amended cost title served upon us.
Within a period of 2 weeks from the date of carrying out the amendments by the department concerned. Department যেটা বলেছে সেটা 2 week বলেছে তো, department shall carry out. First up, the added respondents will be at liberty to file an affidavit in opposition to the amended writ petition within a period of 3 weeks after service of the copy of the amended writ petition. First up, reply thereto, if any, be filed within
1 week.
2 weeks, within a week thereafter. First up, the parties will be at liberty to mention for inclusion of this matter for hearing after expiry of the period fixed for exchange of.
Miller, only 2 things, Miller. Miller, the pleadings be served upon the corporation and the amended cost title. Only the cost title be served upon the.
The learned advocate on record of the. No, what pleadings be?
The pleadings, Miller, the affidavit in opposition and the reply. Miller,
Who will serve?
The respective parties will serve upon us. Miller, ultimately, we will not know. They will take point against us, maybe.
The learned advocate on record of the petitioner is directed to serve a copy of the amended cost title of the writ petition upon Mr. Nag, learned advocate for the Vidhannagar Municipal Corporation. First up, the parties are directed to exchange the pleadings on or before the next date of hearing. Yes, next.
20.
I am for the petitioner, Milord. Milord, in this matter, we are having contradictory instructions from our respective clients.
Contradictory instructions.
Milord.
You are for?
I am for the petitioner.
You are for the petitioner?
Milord.
Yes.
My clients told me that a talk for settlement is going on between them and the government representatives. Today, my learned friend says that no such instruction is with him.
What is the issue?
Issue is, Milord, a government land with some incomplete brick cleans were given to the petitioners under lease. They developed the same
government land
with some incompletely constructed brick cleans. The petitioners developed that with their own cost, and thereafter they were operating them as lease. Now, regarding the enhancement of rent, a dispute arose. That is why the petitioners came before your lordship.
Enhancement of rent as fixed by in the lease deed.
In the lease deed, and subsequently it was arbitrarily changed during the subsistence of the lease.
How can that form the subject matter of a writ petition?
It was admitted at that point of
Contractual dispute.
But in fact,
What-
my lord, the
what-
lease has expired around 5 years back.
what I submit, my lord, in view of this. It is for my satisfaction. Since I had that specific instruction, kindly fix it any date after 20th. I am talking to them once again. I am informing them that this is the submission of the learned advocate for the state, and thereafter I shall come. Or if they have any
It is not
document,
maintainable at all.
Yes, sir.
that point was taken at the initial stage, and appeal was also preferred. That was also disposed of.
Appeal court held,
Appeal court
held that
disposed
the
of the
petition is
application,
maintainable.
Remanded the matter back to the.
remanded the matter back to the learned single bench.
No, appeal court has decided anything on the maintainability issue.
No, not on maintainability.
Not
That point was not taken by the state at that stage.
State did not take that point.
That point was not taken.
I was not appealing.
Then I'm also not taking that point.
And
Kindly,
that point has been taken in the affidavit opposition in the writ petition.
kindly fix a date after.
That is the general point taken,
That is no, my lord, I've taken a specific point that the writ is not
but
maintained.
not urged with full force.
At that point of time, we were not there, my lord. It was on 18 matter. We were not there. But my lord, when we came up
Any-
my lord, and we filed an affidavit, extensive
any-
affidavit,
So I'm directing this matter to go out of the list. After that, you
you also
mention
may
for
kindly hear
inflation.
on this matter, my lord. This matter
He
is being-
says talks of settlement.
there is no such
You are
talks.
not affected by this.
No, my lord, we are affected because my lord, the lease has expired around 5 to 6 years back. They are
Yes,
still holding the land, and my lord, they are.
you take steps for that. Nobody is preventing
No,
you.
but
There is
that-
no interim order.
There is an order, my lord. There is an order. That order has to be interpreted. Your lordship may kindly takes up this matter next week, my lord.
Any date after 20th, my lord. After 20th of this month.
20th of this month. All right. The learned advocate appearing for the petitioner submits that talks of settlement are going on. First up, Mr. Siddiqui, learned advocate, appears for the state. First up, as prayed for by the learned advocate for the petitioner, list this matter in the month of December 2024 under the same heading.
The semitic, my lord, fairly at the top, your lordship.
It's fairly at the top.
My lord, then monthly list, my lord, it will
You
go down.
want further top to be above in the High Court at Calcutta. Yes, next. What are these applications? So many applications.
They have
What-
taken out several applications
What
for
for?
extension of interim order, for extension of lease, my lord. There are several applications they have taken out.
Extension of lease. The
But
Writ
then-
Court will pass a direction for
No,
extension
not
of
on
lease.
extension of lease. Some orders are
You are
arbitrary.
not pressing that. Let me dispose of that.
Those are
I'll have to check, my lord. Some applications, those specific applications which are infructuous, those may be disposed of. Kindly do not,
Which have become infructuous, unnecessarily making the list clumsy.
on the next day, I shall make some specific submission.
Yes, next.
21. I appear for the petitioner. The petitioner, with your lordship, he was an
This is
employee.
the respondent.
So Mr. Mukti Chandra Ghosh, because it's a government company, now the company is in liquidation. Yesterday he was there, I had a
Was
talk
there.
with him. I told him that this bench, possibly this week, this bench will continue. So you remain present.
You have
Yesterday he
information
was
that-
there.
You have information.
I
for
said
this
that
week, this
possibly.
will
I said that possibly this bench will continue for this week.
I'm passing it over. Informing. Pass over next.
22 also, lordship.
Same pass over next.
23.
I appear for the petitioner. This is against Howrah Municipal Corporation. Mr.
Ankit Sureka.
Ankit Sureka and Mr. Pinaki Chakraborty was there.
You are appearing.
Lordship, this is with regard to the petitioner. He was initially appointed as assistant engineer under Howrah Municipal Corporation.
You are appearing for Howrah Municipal Corporation. Yes.
Pinaki Chakraborty nahi hai?
Petitioners were appointed.
As assistant engineer in Howrah Municipal Corporation in 1987. He continued for a period. Thereafter, he got an opportunity to appoint under the Ministry of Surface Transport on deputation basis. The post advertisement was for transfer on deputation basis. Lordship, may I just tell you, Lordship, the background of the case, and their Lordship kindly go through the documents. I prepared a list of dates. Possibly that was handed over to your lordship on the last occasion. The brief history is there. He was appointed on 27th of November 1987 as the assistant engineer, Howrah
What is
Municipal
your
Corporation.
prayer now?
Now, let's see, I am not getting pension. After I was appointed in 87, thereafter there was a gap because under wrong impression, I tendered resignation because initially Howrah Municipal Corporation permitted me to appear in the selection process, which was on transfer on deputation basis. They issued no objection, vigilance clearance, and at the time of releasing me, they insisted me to submit resignation. Also, without going through the implication of submission of the tender, the petitioner tendered his resignation.
Then what can be done?
And
So you have resigned.
no,
So there is a
Lordship,
proof of service.
I'll show that even after that, after my came back and I was rejoined in Howrah Municipal Corporation, then also my service period much more than the eligibility period, because in 1999 again appointed in the same post.
All right.
So since 1999 and continued, I retired in 2022.
So you have covered the minimum
Yes.
qualifying service even
That is
from
10 years. I have
1999.
completed that. In spite of that, they are not getting. I am not getting pension.
So you are not pressing the earlier part. Period. You have
The
to
writ
choose between
petition. The writ petition is for continuation of my past service, because there is a recommendation of the chief auditor that this period, this should not be treated as break of service. This should be treated as transfer on deputation basis, because the matter was relegated by the municipal commissioner to the chief auditor. The chief auditor, after careful consideration of all the documents, passed an order. That order was placed before the board of councillors, and ultimately board of councillors, overlooking that recommendation, passed an order that this period should be treated as break in service.
All right. Come at 2 because I have another
So
pen.
possibly 2 PM, there are certain matters fixed.
There are 2 matters fixed. Thereafter, it will be taken up.
Yes.
It 2 PM at 4. Sir, I commenced your argument.
Yes, I have started the
What was the commencement?
Yes.
regarding, my lord, the nature of acquisition. Before that, my lord, you sought, I want to refresh the memory, my lord. The proceedings was initiated, it appears from the documents. The proceedings was initiated for the purpose of acquiring the land of the petitioner. That is plot number 42.
Plot number 42.
42.
Under what provision?
Act 1. 1894, section 4 was there. Section 6 was there. The documents which they have annexed, subsequently a corrigendum was issued.
Affidavit has been filed.
Yes.
Yes. Thereafter, corrigendum.
According to the requiring body, their stand is that the entire plot of land has been
Bag is for the requiring body.
BSNL.
So
The state is
I am for the
you are for the
patient.
BSNL. You are for the Union of. You are for Union of India.
but the state is the main person who can enlighten everything.
State
State. Because the acquiring body
is for the state.
yes, the name is appearing, but Ganguly and Subroto Dasgupta. Their presence is necessary. Why, my lord? According to the affidavit filed by the requiring body, their stand is that the entire plot of land has been acquired. And they have deposited the money for the purpose of disbursement of the award amount. But from the document,
In the absence of state, can
that is the main thing, my lord, we are facing. On the earlier occasion, this was pointed out to your lordship. And why, my lord, if your lordship can turn to the decree, there is a civil suit where it was declared only to that extent the title of the.
Roy Mukherjee. She appeared on October.
After
10,
that, my lord,
2023.
August 2023.
Ashim Kumar Ganguly appeared on 4th of August 2023.
Yes.
Have you informed them?
Inform করবে.
It has come up at your mentioning.
No, it was there. Upon notice, it is not that.
You have to sub notice.
Notice না নোটিশ দিয়ে সব ইয়ে করা হয়েছে জজ সাহেবের কাছে উইদাউট নোটিস মেনশনিং লিস্টে থাকবে বলছি নোটিস দিয়ে কতবার নোটিস দিয়েছে আগে
Then, Mr. Rai, what can be done? If you say that state is the effective
because why, my lord? Subsequently, a procedure is
not why. Then, if the
no,
state is
the
not
reason for that because I have to substitute by stand why the state's presence is necessary, not that because
Mr. Siddiqui.
Siddiqui. Hey, chalo sir.
You are the state, Mr. Siddiqui.
No, I'm the state, my lord. Mr. Khalid is big state.
Nobody is appearing in this matter. Mr. Ashim Ganguly was
recorded in earlier 2 or 3 occasions.
yes in August
Happy,
2023.
I'll inform Mr. Ganguly, madam.
Yes, yes, kindly.
I'll inform him.
Has he come today?
I've seen him. No, yeah, I saw him yesterday. Today I have not seen him.
Yes, sir.
You can contact him so that it can be.
15.
Oh,
Now, if your lordship can text up the writ application.
Then, Mr. Rai, I'm passing it over if Mr. Ganguly comes. There is another 2 p.m. matter. After that, I will be
As
taking
your
up.
lordship pleases. As your lordship pleases.
Just let Mr. Ganguly come.
Because in respect of the sales and property, subsequently government initiated and acquisition proceedings.
Let him come. We do not know whether he is ready. He will say, affidavits have been filed.
Not by the, they did not file. State,
That I don't know, state has not been filed, I think. Whether state has filed or not, that I have.
no, we have not been served.
He
We
is
have not
saying
been
that-
served.
Yes,
are not
call the
with
other 2 p.m. matter.
16.
Ashok, tell it.
Mr. Millard, I beg to appear for the state respondent lordship. Millard, so the requisition was, lordship has already heard Millard, my learned senior friend Millard. That requisition was of Millard 12 point something plus. And section 4 acquisition notice was Millard of 10.34 acres. Milord, the requiring body, Milord, has also, Milord, has placed on record that possession certificate also, Milord, they have shown before your lordship list that they have taken over possession of 10.34 acre. Milord, requisition. Prior to that, Milord, we have undertaken, Milord, one preliminary inquiry report, PIR. If your lordship, we may respectfully invite your lordship, Milord, to our opposition, Milord.
Opposition.
Not opposition. No, we had placed one reconstructed record, Milord. It is, Milord, on record, lordship.
There is no opposition,
No, opposition is there.
but you want to place on record, you want to rely upon that reconstructed record.
Yeah, I want to now, Milord, because it is already on record that was placed pursuant to the Honorable Milord Court's order, lordship.
Yes, preliminary inspection report.
Lordship, it is a part of that bunch of paper that they
Yes,
got,
preliminary
lordship.
inspection report.
Lordship.
Yes.
If I may respectfully invite your lordship, Milord, to the preliminary inspection report, kindly seize, Milord, the very first page. Total area of land proposed to be acquired is 12.48. She got that. Wasteland unfit for cultivation 10.34. Homestead lands 2.12. This was the categorization of total 12.48. Now, if I may respectfully invite your lordship, Milord, to the next page, Milord, kindly sees what is the recommendation of the inquiry officer. He writes something on that day. The original retained under RA Act heed by the so-and-so. Order problem have so-and-so include the squatters on the portion of the scheduled land measuring an area of 2.12 acre, covering portion so-and-so. It may therefore be considered if RO is to issue.
What is RO, Mr. Gali?
Revenue officer, requisition officer.
If RO is to be issued.
Or requisition order?
Yes. If requisition order is to be issued, excluding the said area.
Funny.
Now, Mr. Gali, what is the date of, what is the date of this report?
This report comes on 23rd May, Milord.
1979.
1979.
Very good.
Now, Milord, followed. So this is on 23rd May 1979. And the possession certificate which the requiring body has placed.
No. After that, where is the
After
order?
that, after
where is
that,
the order under section 3.1?
After that comes a. I am showing. It is a part of this only. The last page. The last page of this bunch of document. The last page, total requisition area is 12.46 acres.
Yes. So,
despite the recommendation, the 2.12 acre is lying with the squatters. Hence, requisition under section 3.1 may be made of excluding that portion, but requisition under section 3.1 comes on 12.46 acres. And that also comes, Milord, on the self-same date. But preliminary inquiry report, Milord, categorically holds that 2.12 acre is with the squatters.
Followed by which will prevail, the preliminary inspection report or the requisition order?
Here comes, Milord, the
which
catch
one will
word.
Prevail over the other? Which one will prevail over the other?
Milord, if I am to go by the statute, section 3.1 will prevail over the preliminary inquiry report. As an officer of the court, Milord, there is no escape from this particular point. But, Milord, the Milord, bone of contention lies with regard to, Milord, handing over and taking over of the possession from the acquiring body to the requiring body. Milord, if your lordship comes to the finding that under the scheme of Act 2 of 1948, if section 3.1 requisition notice is synonymous with taking of possession, hence, Mr. Gali, you are out. Whether you got possession of 12.46 or not, I am not going to consider. Because section 3 requisition notice itself means synonymous with possession. I am out. But my lord, if it is to be seen that section 3(1) requisition notice under the scheme of Act 2 is not a synonymous with taking of possession, then my lord, I am there to argue the matter before your lordship. In my respectful submission, my lord, it is not synonymous with taking of possession. Had it been so, then the concept of section 4 would not have had come into place of Act 2. So, my lord, let me first clarify the fact. So, PIR says 2.1 is under squatters. Hence, you may give requisition order of 10.34. Nonetheless, requisition comes in 1970 entire 12.41. Now, on 30th May 1979, after, when a possession is being handed over to the requiring body, we are getting possession excluding the 2.12. It is a settled fact, undisputed fact. After that, so my lord, when the requisition is being made, it is on the proposal of the requiring body, as in case of Act 1 also. The proposal comes from the requiring body that we want to construct or set up or establish this project. Hence, it's Mr. State Government, we want this quantum of property. They give the plan also. From this moja, this moja, this moja, we need this quantum of land. So proposal comes from the requiring body.
What was the proposal from the requiring body?
Requiring body must have asked for my lord, this particular amount of quantum of 12.41. Must have. 12.4 must have. That is why the requisition of 12.41. But finally they get 10.34. Now my fundamental, my first respectful submission is the section 3(1) cannot be read as synonymous with possession. That is why, since we could not get physical or khas possession while issuing section 3(1) notification acquisition, this particular 2.12 acre of land cannot culminate to section 4(1) notice. If I may respectfully read out, my lord, section 4(1) of the Act 2. My lord, may I read out, lordship? My lord, having issued requisition under section 3(1), what does section 4 says? Where any land has been requisitioned under section 3. My lord, lordship has a copy of this Act 2, my lord. My lord, section 4.
4(1).
Section 4(1). Where any land has been requisitioned under section 3, the state government may use or deal with such land for any of the purposes referred to in subsection 1 of section 3 as may appear it to be expedient. Next, the state government may acquire any land requisitioned under section 3 by publishing a notice in the official gazette that such land is required for a public purpose referred to in subsection 1 of section 3. Where a notice as aforesaid is published in the official gazette, the requisitioned land shall, on and from the beginning of the day on which the notice is to be published, vest absolutely in the state government, free from all encumbrances, and the period of requisition of such land shall end. So, Miller, so far as 2.12 acre is concerned, it did not culminate into the issuance of section 4(1) a notice.
These are admitted.
Lordship, no, lordship, lordship.
These are Mr.
Why, my lord?
These are admitted.
Lordship, why? Why it could not culminate or reach the point of section 4(a)? As because section 4(1)(a), one of the principal ingredients, my lord, in my respectful understanding, will subject to your lordship and correction. One of the ingredients is only when section 4(1)(a) notice is being issued in respect of that land which was subject matter of requisition under section 3(1). From that day, point number 1, it will vest in the state absolutely. And point number 2, it will vest free from any encumbrances. Now, my lord, the Act has given, my lord, Milord, the definition of encumbrances, Milord. If I may, Milord, specifically invite your Lordship, Milord, to the definition clause, Milord, section 2, Milord. Section 2, Milord, small b, Milord, small 1b1. Encumbrance in relation to any land includes all rights or interests of whatever nature belonging to any tenant, licensee, or trespasser, or any other person. So, Milord, we cannot culminate the requisitioned land of 2.12 acre into section 4.1 because it was not free from any encumbrances. So, Milord, on the date that is in 1979, when the requisition, Milord, in the section, Milord, 3.1, Milord, of the Act 2 was made, it was a specific case of the, Milord, of the acquiring body that it was not free from encumbrances. So far as 2.12 acre is concerned, it was with the squatters. That is why it could not culminate into section 4.1. 4.1 essential ingredient is that it has to be free from encumbrances.
Section 4.1a, once this is published, it will vest free from all encumbrances. It does not say that a land with encumbrance cannot vest in this state. It's otherwise. Any encumbrances, irrespective of that, it will vest. It's the other way around. Subject to correction by you.
Milord, Milord, in my respectful understanding, requisition is a stage, Milord, under section Act 2, where the property does not vest. Milord, the fundamental difference between, Milord, the requisition and acquisition, Milord, as contemplated, Milord, on section 3 and section 4 of the Act 2 is, Milord, has been a subject matter, Milord, of interpretation, Milord, by the Honorable Supreme.
Mr. Gali, what is the effect of requisition? We are not on acquisition.
Requisition, as contemplated in the scheme of Act 2 is that government cannot acquire more than the land which has been requisitioned as section.
Not on that.
This is the meaning.
What is the effect of requisition?
Requisition is meaning is
Can the government take a land on requisition, keep it for certain period without acquiring?
That is why there is
the government requisitions a land, keeps it under requisition, say for 5-10 years,
Lordship,
and decides thereafter not to acquire.
I don't want to go for acquisition.
Can it be done?
It can be done. That is why there is a provision.
It can be done. Yes.
Lordship.
If it can be done,
sorry.
What is the effect of that requisition for these 5 or 10 years? What is the effect?
My lord, effect is well settled.
What is the effect? I want to know.
If you are not acquiring if you are not issuing section 4.1a of a requisition land under section 3, you release it under section 6. You release under section 6.
Yes.
And for that period, you are to pay the rent.
That is one thing. Lordship. What is the effect of this order of requisition? I want to know the effect of the order of requisition.
Effect, my lord, that is where, my lord, I am on. Effect.
Can an owner of the land whose property has been requisitioned during the period when the requisition order is in subsistence can utilize that land for whatever purpose he wants?
Certainly.
Can. Do you have any authority on that?
There is a division bench judgment that...
Then how do you read subsection 3 of section 3?
My lord, subsection 3
of section 3.
My lord, subsection 3, yes.
Read with
my lord.
Section 6 of this act.
My lord, subsection 3 of section 3 is, my lord, may I read out, my lord? Lordship, had me pleased to, my lord, advert to this, my lord, at the time of hearing in the first.
So requisition order, Mr. Galib, you said an order of requisition has been passed. The owner is free to enjoy that property according to his own whims.
Certainly not. Certainly not.
You said yes, there is nothing. That is why I asked you what is the effect of. So he cannot. So he is deprived from enjoying
his property as he likes.
Yes. During the period of requisition.
Yes.
So the government can use that property during the period of requisition according to the wish of the government.
Lordship.
So the owner is deprived. Yes. Thank you. Next.
It is a settled proposition, Lordship. It can't be. But the question is, here as on date, my lord, the very act has died a natural death in March 1990, my lord, 4. Now, my lord, my learned friend, today, yes, certainly he can say that I want release of it. That is a prayer also. The release of the requisitioned land. Release of the requisitioned land. My learned friend, my lord, has also, my lord, annexed one document in the writ petition. If I may respectfully invite your lordship, my lord, to page, my lord, 39
Of the
writ petition. This is also a government document, my lord, which is being, my lord, issued by the of OSD to the land acquisition collector. Page 39 of the writ petition.
Yes.
Here, my lord, it says the release of 2.12 acres of land in Mosa so and so. And so this OSD is directing the LA collector in the year 2008 that in sending herewith a copy of the letter dated so and so from Mr. so and so, the undersigned is directed to request him to conduct an inquiry to ascertain the present status of the land and a report with his view to this. So this particular letter, if your lordship, my lord, if I may respectfully invite your lordship to section 6 of the act once. Section 6 of the act says, lordship may kindly take up, my lord, the book once. Section 6, where any land requisitioned under section 3 is not acquired and is to be released from requisition, the state government may, after making such inquiry, if any, as it considers necessary, specify by order in writing the person who appears to it to be entitled to the possession of such land. So, my lord, this inquiry has to be, my lord, conducted. So, in my humble understanding, page 39 is, my lord, perhaps with regard to such inquiry, it was directed to be done.
What is the fate of that inquiry?
Well, as on date, I have not got any update, to be very honest with your lordship. Now, secondly, my lord, if a release of the requisition land is also to be made, since, my lord, requisition of any land is also being done on the proposal of the requiring body. So, their consent is also, my lord, is one of the, my lord, criteria, my lord, to be obtained from them, that whether they at all.
Requiring body is here.
They are willing to
let him object to that.
So, my lord, the question is that if the release is to be made, an inquiry is to be conducted. And secondly, the requiring body is also to be taken into confidence. Thirdly, my lord, since the land was not free from encumbrance even on the date of requisition, in my respectful submission, my lord, I may have to use the written notes of submission, that if at all release is to be made, it has to be on as is and whatever there is basis. I am reading out section 4 only for the reason that this 12.41 acre could not culminate into section 4.1 only and only for the reason that 2.12 out of 12.61 was with the squatters on the date of requisition. It was not free from encumbrances. It was not free from encumbrances even on the date of requisition. So even if section 6 of Act 2 is to be pressed into service, provided the requiring body says we don't need that, the release can be done only on as is, where is, and whatever there is basis. Since state government in the year 1979, while my lord undertaking a preliminary inquiry, it found squatters. So these people cannot be said that they were on the permissive possession of the state government. There was a case, there is a division by judgment, reported judgment, my lord, presided over by my lord Justice Bhaskar Bhattacharya. That after acquisition, government set up a destitute women's home. That land did not culminate into acquisition. Now owner came for release. So in that perspective, it said that since there was a lesser relation between the occupants of the women destitute home, but here that is not the case. When the requisition itself was made in the year 1979, there were squatters occupying 2.12 acres. Hence, that cannot fructify into Section 4. So, Milord, I am at one with the Honorable Court also and with my learned friend.
One thing, Galib, you started by submitting that Section 3.1 order does not contemplate, ipso facto does not contemplate possession, taking of possession from the owners. How do you substantiate that submission from
Milord, there are two judgments, Milord.
What is the procedure for taking possession of the requisition land from the owners or the occupiers as per Act 2 of 40?
Milord, Act 2, Section 3, subsection 3 says that an order under subsection 1 shall be served an order under subsection 1 is requisition order. Subsection 1 of Section 3 requisition order. Now, subsection 2 says an order under subsection 1 shall be served in the prescribed manner on the owner of the land.
This is with regard to service. What is the effect of this order? What does the
Lordship
order
was asking me
contemplate?
that. Lordship was pleased to ask me this question, my lord, and I had given respectful reply to the.
From the statute, show me the provision. What are the provisions? How to take possession? Where does the statute provide for
Yeah,
taking of
it says
possession?
to enforce the delivery of possession. I am on that.
Mr. Galib, enforcement is execution.
Lordship.
Let us suppose the owner voluntarily, you pass an order and the owner voluntarily gives possession. There is no question of executing this.
So, my lord, execution of Section 3, subsection 2, my lord, here does not come.
What is the effect of that? What does that order mean?
I'm on that. Requisitioned property means. This is what the Honorable Supreme Court says. Requisition meaning is that yes, the owner cannot touch it. But the purpose for requisition under Section 3 of Act 2.
Who will be in possession? When a requisition order has been passed, possession. I am on possession. Who will be in possession of the property?
My lord, in the facts and circumstances of the case, lordship, symbolic possession goes to the state government.
Thank you. Yes. So symbolic possession is with the state government. Once an order under Section 3.1 is passed. Symbolic possession is with the state government when an order under Section 3.1 is passed. Now, if the person who is in actual possession does not give possession, then 3.3 possession, actual physical possession can be taken. If not taken, state is in symbolic possession.
But, my lord, Section 3.
That is your submission.
No, my lord, lordship. Kindly appreciate. The Section 3.1 symbolic possession, my lord, is to be understood in the context and context of Section 6 and the meaning definition of the word encumbrance. So, on the date of requisition, 10.34 could be handed over.
No, I am not on the quantum. I am on the statutory provision. 3.1, an order is passed.
My lord, may I
Who is in possession of the property?
Lord, may I respectfully place, my lord, the fundamental difference between requisition and acquisition which the Honorable Supreme Court has said, my lord. The fundamental difference, my lord. My lord, one judgment, my lord, of our honorable court, my lord, a coordinate bench, my lord. This is reported in, my lord, 2000 volume 2 CHN. 2000 volume 2 CHN 771. May I, my lord, straight away take your lordship, my lord, respectfully, my lord. So, my lord, paragraph 10. Paragraph 10, lordship. It Shomorendranath Paul and others. My lord, paragraph 10 may only first 4 lines, my lord, I will read out. Before I proceed further, it is recorded that the notice of acquisition issued under subsection 1A of section 4 of Act 2 of 1948 has no independent existence under Act 2 of 1948, inasmuch as such acquisition is permissible only upon requisition of the
There is no
property.
dispute, there is no
Wait,
quarrel to this proposition.
So
Statute is
so
clear.
that is the
First requisition, then
so
acquisition.
the purpose is, my lord.
4(1)A cannot exist without requisition. Statute
And, my
says
lord,
so. It's
and, my
clear.
lord, and, my lord, another very categoric, my lord, of Honorable Supreme Court 2018, my lord, 2018, volume 13 SCC 623.
Yes.
My lord, paragraph 12.
Yes.
My lord, paragraph 12, my lord, says of the report, my lord, it is apparent from the aforesaid provision that was on this, our Act 2 of 1948, my lord. The property that is under requisition can only be acquired. Requisition is a sine qua non.
Mr. Galib, there is no quarrel to this proposition. It's well settled.
So, my lord, possession.
Because section 4(1)A starts with when a land is requisitioned, the government decides to acquire.
So, my lord,
So there cannot be any acquisition under Act 2 without requisition.
So, my lord, question of possession, my lord. Question of possession, my lord, cannot be read with synonymous with section 3B.
Then you have handed over possession, Mr. Galib, to the requiring body.
10.34, lordship.
Yes, yes, yes. So 10.34, how have you taken possession from the owners? By what document? By what means? I'm on 10.34, not on 12.46.
10.34.
How have you first? You have to take possession from the owners. How have you taken possession from the owners? By what mode? Show me from the statute.
My lord, statute says, my lord, the enforcement of delivery of possession takes place.
Mr. Galib, that is enforcement. So first you have to, where does the statute provide for taking possession?
As such, my lord, it is just giving a serving of notice.
Notice is order. So that is the effect of possession. Once an order is passed, the person will not know prior to that. Only upon an order is passed, he knows government has requisition.
Lordship.
There is no other mode after that for taking of physical possession from the owner by the state. And giving possession from by the state to the requiring body is an internal arrangement
taking of possession
between the state and the requiring body, for which the owners or the occupiers have no role to play.
The possession, my lord, kindly appreciate.
Because first, Mr. Galib, the possession was with the owner. Admittedly was with the owner. Let us assume, let us for the moment keep aside the occupiers. The possession was with the owner. You pass an order under section 3(1). He was in possession. So you have to take physical possession. How he will take physical possession? Statute does not say so. Says, yes, order is passed, service. Thereafter, come to subsection 3. If any person fails to comply. So execution is failure to comply. Let us assume the person complies with that. Then there is no question of execution. So possession, once the notice is served, possession is deemed to have been taken by the state. You have taken possession of that. Now, if there is obstruction or failure to comply, then obviously recourses are available. You can enforce through the magistrate.
My lord, may I read
And you have also rightly submitted that state was in symbolic possession.
in custody? In custody, once the requisition under section 3(1) takes place, the property goes in the custody of the state government. This was the interpretation given in Mangalahar Kevalchand Mimani judgment. During the requisition period in that case, during the requisition period, the lazy Kevalchand Mimani was in possession. Now, when the government was willing to de-requisition the property, the lease period expired by a flux of time. Now, state government wanted to hand over the possession to Kevalchand Mimani, the lazy. Now, the actual owner, they approached the Honorable Court. Our court said, no wrong, you hand it over to Mimani. Owner says, his lease has already expired. So why are you giving him? Give it back to me, I am the owner. So the owner, they agreed by our court's order, they went to Supreme Court. Supreme Court said, no, it has to go back, my lord, to the owner, because during the acquisition period, when you are taking the property on requisition, he was there as a lessee. But on that day, when you issued Section 3, the custody of the property went to your state government. Now, during the period of acquisition, Mimani's lease period expired by flux of time. So now, since beyond that period, you are willing to de-requisition the property, you will have to hand it over to the owner of the property.
So during the period of subsistence of the order of requisition, state was the custodian.
So, my lord, this is even
Was the custodian of 12.46 acres.
Yes. Even public land removal of encroachment act, if your lordship sees the definition of public land, it says public, definition says public land is that land which has also been requisitioned by the state government. Public land definition is there in the Public Land Prevention of Removal Eviction of Public Land Act. So when here requisite custody in the, that's why question of release comes in Section 6. It has to be by inquiry. And during the requisition period, then compensation shall come forward. But here, my lord, the factual aspect is different. Here, release, if at all, can be made subject to the concurrence of the requiring body.
That I will hear the requiring body on that, whether they have any objection.
But, my lord, lordship is very much clear, my lord, on record that 2.12 even was not within the custody of the state government. In possession, not custody, possession of the state government. It was with the squatters. So, release, if at all.
Something you can make your submission.
It's a very ticklish question.
Don't put that words into the mouth of the court.
No, I don't want lordship. But, my lord, it has to be
that is your submission.
As is varies, and whatever there is basis, if at all. So, my lord, may I just specifically use one short notes of this
what note of
argument?
What are these are the arguments? How you will improve by filing a short note of argument? Anything more you want to incorporate in this short note of argument?
So inquiry was undertaken, I find, as from one of the annexures of the inquiry was directed to be undertaken.
You have not done from 2008, nothing on record to show. No. Today we are in 2024. How long it will take for inquiry?
The entire record had to be reconstructed, my lord, on the order of
that is neither here. You are the custodian of your own records.
Section 6 was
you are the custodian of your own records. You have misplaced it. You have destroyed it.
But Section 6 was placed into service, as I find from annexure, my lord. Page 39. Section 6, my lord, I find was pressed into service.
Yes. There's the letter.
As I find from page 39 of the writ petition.
Yes.
So, if I may, I don't know whether I can get any update over this or not. If your lordship.
What update you cannot get?
Says,
2008, no records available. You have your own admission is no records available. How can you get some more records?
But admission, my lord, they have placed one I'm on the transfer.
Reconstructed. Reconstructed means you said these are the only records available. That is an admission that you do not have any more records.
And one more thing, my lord, the release has
otherwise it will be constituted you are withholding the records. Your other submission is to be accepted. Then you are trying to withhold the records by producing only these reconstructed records.
That cannot be.
Don't make that submission. Yes, yes, Mr. Mitro. Now the ball is in your court. Mr. Mitro, can you hear me?
audio disturbance. There is an audio disturbance. Is it- My lord, am I audible to your lordship?
Yes, now you are audible. Mr. Mitra, you
My lord,
could
with regard,
submission of Mr. Galib.
yes, because my lord, with regard to my lord, the very limited fact wherein my lord, the SI corporation, my
Only your assistance is required because Mr. Galib says because
Yes.
the consent of the requiring body is necessary for releasing the balance 2.12 acres. If you say no, you want that 2.12, that is one thing.
No, my
If you
lord,
require 2.12, that is one thing. Whether you require that 2.12,
no, my lord, with regard to my lord, that particular my lord, aspect, if I my lord, need to apprise your lordship, I'll have to take instructions because so far my lord, as I have gone through my lord, the documents that has been my lord, lying with me, I felt that the purpose is served by way of my lord, the amount of the land that has been my lord, handed over
because it's soft, so you don't
to
require
my
the
lord,
additional amount. And if you require, you can make a fresh
I may, my lord,
state can very well have power to acquire
I-
that land. That balance
if your
2.12.
lordship, my lord,
For the present, you said that your purpose has been satisfied.
that is something my lord, which I did not.
For that quantum, you are well open to give a requisition to the state for acquiring that 2.12.
I believe, my lord, whether that would be, my lord, a risky submission on my behalf, my lord, to make before your lordship. May I, my lord, just take a short instructions with regard to the fact that whether, my lord, that will suffice, my lord, serve the purpose or not.
Yes, Mr. Bera. Anything in reply?
Brother, the argument which has been advanced by Mr. Galib, only I want to say mainly with regard to the concept of encumbrance which has been sought to be argued by my landlord.
You wanted to submit, as I could understand, that if a land is not free from encumbrances, that cannot be acquired.
No. I want to say
land was encumbered.
whatever may be the status of the land, whether it is occupied by trespasser or etc. etc. My lord, Section 3 can be issued in respect of the land which has been squatted also. Encumbrance
And
has
4.1a also can be done on that.
Encumbrance.
If it is done free from, state will get it free from all
encumbrances. So
that is the effect of
that is the effect of the scope of this Act 2 of
Mr. Gali wanted to put it in the
put in a
reverse
different
way.
way. It is
That
not
is
the
why I
case.
said
It is not
that you
the
wanted
case
to put
that
it
if
in a
the
reverse
land is encumbered, the property cannot be requisitioned.
According, yes. That's
Can be requisitioned.
That's not the concept of 4.1a.
Concept of Act 2, my lord. If land is requisitioned,
Neither 4.1a, not
once 4.1a by
My interpretation is this, that with respect of 2.12, we cannot go till the point of 4.1 as because it was not free from encumbrance.
No, that is not the concept of Act 2. Concept of Act 2 is any land which is required by the government.
Even it is encumbered.
If it is encumbered and
once 4.1a is issued,
yes,
it
particular
will
language.
free from
Yes.
all encumbrance.
Then your 4.1a comes, then 4.1a says free for encumbrance. What is encumbrance? If the land is trespassed by somebody, that will be free from encumbrance. Trespassers have no legal right to continue with the possession of the land. Once it is 4.1a published, absolutely vested in the government. That is the concept of encumbrance.
And what is your reply with regard to his submission that 3.1 does not contemplate possession?
It's automatic. Because there is no, I already at the time of my initial submission, I told submitted before your lordship that there is no different mode of taking possession like Act 1. There is two mode of possession under the Act 1. If it is urgency, under Section 17.1 and 17.2. If it is after regular acquisition, then after declaration of award under Section 16, that too by serving a notice.
Formal taking over of possession.
That too both by serving notice upon the landowner. Here, notice has already been served under Section 3. No fresh notice is necessary. Whether I go or not, that is not important. When the notice is been served, it shall be named, the government will take possession on the date fixed. On the spot, they found that some portion of the land is being occupied by trespasser, so it cannot be taken possession of. It is not correct because the subsection 3 of Section 3 prescribe the procedure of taking possession. And secondly, the land which was requisitioned by the government, entire land can be acquired by 4.1a, then the every encumbrance will be. So it is synonymous with possession, automatic possession, when the section 3(1) is served upon the land or the occupier. Then again, they.
So when notice under section 3(1)
Then again,
is served, under section 3(2), possession is deemed to have been taken on that.
Then again,
Also,
my lord,
position on as is where is basis.
then, my lord, as is where is basis, that's why incumbency is there. For one, then one thing more is, my lord, even if they found on the spot that it is being occupied by some trespasser or they are occupier, they are required to serve notice under section 3. They are also required to serve.
To enforce the order.
To enforce the order. They have not taken any steps. No record is forthcoming. Order of requisition was passed 12.46. Then on the spot they say it is being occupied by somebody. So they to the requiring body they say lesser amount of it, which is not permissible, not within the scope of the Act of 1940. So, my lord, government shall be deemed to be in a symbolical possession. They could have released the land immediately on, my lord, the 30th May when the possession was then. Please see, you take your own steps. Your land is being occupied by refugees or etc. Like the government tried to protect the possession of the refugee or like that at my expense, spite of the fact that you have issued order of possession. Order under section 3 in respect of entire land.
Mr. Galib, only one thing from the preliminary inspection report.
My lord.
It is prior to, my lord, section 3 order.
The next page 2 of that, the top portion, the noting against point number 9, which you have placed,
Lordship.
Can you give a
Fresh typed copy.
fresh type copy of this?
Certainly, Lordship.
Give only this because
By tomorrow? Tomorrow, may I put it on record, Lordship? Through the court officer, my lord?
By
Tomorrow I
tomorrow,
shall put it on
give
record.
only that type portion
Lordship.
and show it to get it verified by Mr. Bera, then hand
My
over
learned
to
senior
him.
has not got
He has
this
not
page
got-
2 at
he has
all.
not submitted copy of.
No, but he has not placed page 2.
No, he has not got
That
at
is
all.
why when your learned junior was placing, he was saying something. I have said there is something in that preliminary inspection report, but there is also a missing link. I have seen that. You have placed prior to that. I have seen this. So, and there is also one missing link that you have not explained. Give a typed copy of this. Get it. He may not have placed that, but he has to go through that, verify that because
The
I will
rest of
rely-
the papers are there, Lordship. The entire.
Yes. Only this is necessary. Other things are not. You have not placed. You have tried to rely upon this. So I have to deal with this.
Yes, because I pointed out before, Lordship, that in spite of all these things, they decided to require that is at para 4. That I have also pointed out.
Yes.
My learned senior friend is telling one thing, that in the scheme of Act 2, Section 3 is synonymous with possession. And that is the only fundamental difference between Act 1 and Act 2. That is not the case. I respectfully beg to differ, because in Act 1, Section 16 contemplates possession. On possession, on invocation, Section 16 only the property vests in the state. Here, vesting word is used only in Section 4, not in Section 3. So, vesting is synonymous with possession. Hence, it is to be read in Section 4 of Act 2, not in Section 3.
I
am not saying that.
It's a case of possession.
Possession.
Requisition is not a vesting, Mr.
vested.
Gali.
No,
Mode
my
of
learned
possession. It's possession. That is why Section 6, release from requisition, is to deliver possession. Section 3 does not contemplate ownership, vesting of ownership. It's only possession. That is why release from requisition is delivery of possession. Nothing with regard to ownership. Ashun, hard
requisition.
I
Release
said
from requisition.
release from requisition. That is all, and by way of delivering of possession.
Lordship,
Nothing with regard to ownership.
no, my learned senior friend is comparing
Hard-
Act 2 with Act 1, Lordship.
Heard the learned advocates
only
for
one
the
thing,
parties.
if it is requisition, some compensation that for the release of the land if they want to release.
During requisition period,
Requisition,
rent compensation.
Rent compensation.
Is there any representation on that? No.
No, because we have asked for acquisition. We made
That is to be decided, Mr. Bera. Court cannot fix any amount.
no,
As
but
per
your
the, as per the law,
lordships will direct, not the amount fixed.
show me the provision for payment of requisition compensation.
Originally section 7(3). Section 7 subsection 3.
This they have to decide. They have to,
I am not, I am categorically
yes,
saying
they have
your
to
lordship
decide
that your lordship.
once if a direction is passed for release from requisition, consequences will follow.
Your lordships will direct to pay compensation for
There
that
are two
period.
aspects. One is whether the state can be directed to release the land from requisition. If that is so, then the question of payment of requisition,
Yes.
as on which date, what compensation, what mode, they have to decide.
Yes. Your lordships, what I am submitting, your lordships may direct for payment of compensation for that period, in this, for the period which remained in
That I
requisition
will
is-
consider.
That your lordship
That I
will-
will consider.
That your lordship will consider. I am never saying that your lordship's compensation will be fixed by you. That is to be done by the competent authority.
ওটা বলে দিই, here heard the learned advocates for the parties, hearing concluded, judgment stands reserved.
নামগুলো দিয়ে দাও।
I'm careful.
Yes.
Kindly record my appearance.
দিয়ে দিন। দিয়ে দিন। এই নামটা গেছে?
Tomorrow, my lord, I shall hand
নামটা
over.
গেছে?
Give only
নামটা
that
আমাদের
type
কাছে এই
code.
নামটা দিয়ে দাও না।
If you want to file any written notes, that by
দিচ্ছে
tomorrow.
নামটা দিয়ে দিন।
But don't include anything
No, I don't
in
want to.
excess of what you have
I
submitted.
don't want to file a written.
No, if you want, you can file.
Lordship has commendable memory. Everything has been noted down. Only, my lord, entire PIR I shall type, or only the clause 9?
No. Only clause 9. Clause 9 and I think clause 4. Clause 4 and clause 9. Show it to Mr. Bera first,
Very
then hand over to my officers.
Lordship.
আমার জুনিয়রের অ্যাড্রেসটাও জানে তো আমরা। জুনিয়রের অ্যাড্রেসটা জানে। আমার ইচ্ছে করে সত্যির অ্যাড্রেসটা জানে।
Let's call the passed over 2 p.m. matter.
ঠিক আছে,
2
Madam,
p.m.
kindly record my appearance.
Hey, I had to 2 p.m. যেটা passed over হলো।
Careful.
My lord, learned counsel Mr. Shantanu Banerjee is out of station.
No,
That's
no,
why-
15.
23.
But I'm extremely sorry. When the matter was called on, I was appearing before court number 17 in the contempt proceedings. So I
Mr.
could not appear.
Rai was very much aggrieved.
Sir, I.
I mean, agree. No.
He said that Mr. Ganguly is not appearing on repeated occasions.
It is not that. I am appearing because of the 3 buildings, my lord, your lordship. You had been to this side, your lordship knows it much better than me. This building, that building, this building.
Appreciate that
And this
it's very difficult.
Very difficult for us, for every lawyer. Not I'm submitting my report. And copy
Report.
report in the form of an affidavit as per the direction and handing over a copy of the report.
Item number 20, which it started. Don't want today. 2 weeks time. No, you are for the respondent. Where is the petitioner? You are for the petitioner. You are agreeable to 2 weeks time. Not this week করে দিন তো item number ওই যেটা 20 টা।
Lord, I have handed over a copy to Mr.
On the
Rai.
prayer of the learned, ওটা record করে দিন, on the prayer of the learned advocate for the petitioner, hearing of, Howrah Municipal Corporation. On the prayer of the learned advocate for the Howrah Municipal Corporation, the hearing of the matter stands adjourned for this week. This week করে দেবেন।
Lord, I have handed over a copy to Mr. Rai. I hope now he's
Mr. Rai,
calm now.
come.
CLM. And I'm handing over a copy.
Any
to the-
exception?
No, do we have to go through it, my lord?
Lord, I hand over a copy to the telecommunication department to whom the land was handed over. Telecommunication, central government.
Same thing.
Hand over a copy.
One time.
We have to take instruction, my lord. So far, our allegation is to some extent admitted.
Admitted?
Yes.
Do you want to proceed on this?
দরকার নেই তো, তোমার দেখার দরকার নেই তো, তাহলে আমি প্রসিড করবো। তোমার কি রিপোর্টটা কনসিডার করার দরকার আছে?
He is for the telecommunication department, Union of India.
Now, I did this.
আসুন। Mr. Ganguly,
আমার দরকার, আমার ফেভারে আছে।
আমি করিনি পার্টি
কি হলো? What
I have
happened?
handed over the copy to telecommunication. তুমি কার হয়ে জানাচ্ছ?
He is for Union of India.
PSNL. I have given. He is the main respondent to whom the land was taken over.
Why are you depriving the Union of India from a copy of the?
hand over.
Give a copy of the report.
Xerox করিয়ে দিয়ে দিস।
Report in the form of an affidavit filed by the respondent number 2 is taken on record. A copy of such report has been served upon the learned advocate appearing for the petitioner in court today. Copies of such report has also been served upon the learned advocate appearing for the requiring body. First up, the learned advocate for the state is directed to serve a copy of the report upon the learned advocate representing the Union of India in course of this day.
Question number 5.
Union of India. First up, yes, when do you want, Mr. Rai?
As your lordship pleases.
Mr. Bag, how much time?
কবে বলো আমরা?
Next week,
পারবে next week এ?
as paid for by the learned advocate for the requiring body, list this matter in the next week.
I mean,
Some precedents.
এই হাইকোর্ট আর ক্যালকাটার উপরে তুলে দেবে।
হাইকোর্ট কে গেল?
এতদিন যাই বলো মুখে মুখে কতদিন তুমি বলতে
Not
হবে তো।
exception. He is supporting your case.
Well, the requiring body is giving exception to the report of the acquiring body.
What if necessary?
Your lordship is
On the basis of your requisition, it was acquired. So the state is taking a report and you will file exception. Then that benefit the petitioner will get if there is anything. You cannot oppose this time. Yes, next.
for your purpose only land was taken.
Yes. You have given a requisition, they have acquired for your purpose. Now you will be filing an exceptions to their report.
Not your lordship is fixing any day or any specific day.
Next week, Monday is the next day, first day of the next week.
One fair not before High Court at Calcutta, but at the present.
Precedence, your prayer, precedence at the top.
No. Retain his position at least, well.
Retain its position, থাকবেই এখানে যেরকম আছে। Next, 22.
24.
Yes.
Petitioner, pilot kindly let the matter not today because
Not
This with regard to a hotel which license has been cancelled by the authority, that DM has passed a decision order pursuant to an order passed by this honorable court. The order passed by the district magistrate has been assailed before your lordship, my lord.
dismissed
The order passed by the district magistrate has been
under,
pursuant to an order passed by this honorable court.
yes, under
cancelled
what provision?
Under the Sarais Act as well as the Pollution Act, the license of the hotel
Has been cancelled.
cancelled. That has been assailed before your lordship, my lord. This has to be heard. Your lordship may kindly takes it up on the next week, my lord. I appeal for the state respondents. Affidavits have been exchanged.
As paid for by the learned advocate for the petitioner, list this matter in the next week. Next.
25 minutes in this matter, and Mr. Amit Kumar Khan is appearing on behalf of the petitioner. He has not come today, only praying for not today.
Not today, next.
26, 27, and 28 also. All these 4 matters.
Not today, next.
26, 27 also.
28.
28 also.
Not today, next.
29. 28, 29 karo.
Twenty-nine.
My lord, Mr. Satyajit Chalukdar is appearing on behalf of respondent KMD lordship. He's on his legs.
Who is appearing?
Mr. Satyajit Chalukdar
Satyajit Talukdar.
for KMD lordship. He's on his legs, my lord.
Who is for the petitioner?
Me.
So Mujumdar, you are for the petitioner.
29. No. Shamim Ahmed, I think so. Lordship. Shamim Ahmed.
Not today, next.
30,
Not today,
31,
not today.
32, 33,
But 32 Miller, I am appearing for developer Miller,
32.
32 Miller. Respondent number Miller 6,
I'm for the petition.
Respondent number 6.
my lord.
Petitioner is not.
I'm
here.
for the petitioner.
Oh, you are for the
On
petitioner.
Monday, Miller, your lordship, no, what I am submitting, Miller, your lordship kindly take up the matter on Monday, Miller. I am today not well to move the matter, Miller. Your lordship kindly take it up on Monday.
I'm not standing on
Monday
the.
top, Miller, Monday top, your lordship kindly take it on Monday top.
As the learned advocate for the petitioner is
So,
present.
but this is related
Prayer
to
of the learned advocate for the private respondent. Private respondent.
private respondent. He
Private respondent.
List this matter in the next week.
The order has been passed. There is an order of demolition. This is the matter, my lord.
Order of demolition. You are challenging the order of demolition.
No, I'm
No,
not
no,
challenging.
no.
So far,
You
there's
want implementation of the order of demolition.
no. So far, the order of demolition, I have challenged. My case is that the plan was sanctioned illegally. Whereas the municipality, what have done by the municipality, by taking the money, they have regularized the plan. That I have challenged.
All right.
May I request only one thing, my lord? If the matter appear Monday, I have not that time may be fixed so that
Time, date, difficult.
that's I know, my lord. That I know.
Yes, next.
On Monday, your lordship.
Yes, yes.
33.
Next will be.
My lord, I am for the petitioner.
33.
Yes, my lord.
So Mujumdar, you are appearing. 34.
Mr. Supriyo Chattopadhyay is appearing for the state. There's a direction, my lord. At least thrice there was a direction, my lord, to file.
Inform him, I am passing it over.
Very well.
33
Kindly make it not today. Let me, my lord, inform
Not
because
today.
no affidavit has been filed.
All right, not today.
Not
Next.
today.
34. I am appearing for the petitioner. On the last occasion, my lord, the learned counsel appearing for the revenue pointed out that my lord, the copy of the affidavit in opposition is not available in his records. Lordship may recollect Mr. K.K. Maiti was appearing for the respondents. So now Mr. Bhaskar Prasad Banerjee would be appearing for the respondents. My lord, what we have been told by the learned advocate on record for the respondents that they are getting the reaffirmed copy of the affidavit in opposition, or getting it reaffirmed rather. So, Mala, they will be serving upon us. So, can it be just not this week so that we can Monday we can
I'm
come
not
back?
recording anything. I'm only making on your prayer and making it not this week.
Not on my prayer, Mala, they are not here.
All right. Mr. Mujumdar, learned senior counsel represents the petitioner. He submits that the learned advocate representing the Union of India has communicated with his junior that some time is required
Yes, yes.
to get the affidavit in opposition reaffirmed.
Reaffirmed.
So, sir, in view thereof, list this matter in the next week.
Next week, Mala.
Can it be done 2 days?
Mala, I do not know, Mala. I am not in a position to make that statement, Mala. Kitna kya karenge? Let it be next week, Mala. If they are in difficulty, Mala, I will not oppose, obviously. I will not oppose. Well, let it be next week. Whenever your lordship will be sitting singly next week, so we'll try our luck. We'll try our luck. I have been told, man, the clerk is clerk to my. It has been reaffirmed, man, they will serve a copy. So
it has been reaffirmed.
It has been reaffirmed. Copy the service code.
Mr. Mujumdar, shall I record that? No.
No, not necessary because man, something will go into the records of the
Yes, yes.
code that will not be.
All right. যা আছে তাই। হ্যাঁ 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 একই 43 না 42 বোধহয়। কৌশিক রেকর্ড ডিআরআই করে দাও।
43.
Not today. Next.
44.
In this matter,
44, Mr. Banerjee, you are appearing
my lord.
for the
44. 44 or 48. 48.
Robin Majumdar.
My lord.
Robin Majumdar, you are for?
For the petitioner, my lord. Oh, my lord.
You are for the petitioner or the respondent?
But I'm for the petitioner, my lord. I'm sorry, my lord.
Yes.
My lord, on previous occasion also, my learned friend appearing on behalf of the private respondent did not appear. My lord, I have given notice, my lord.
Private respondents did not appear.
Appear on the previous occasion.
What is the dispute? Private respondent, why?
Private respondent is the principal of the college.
Principal of the college.
Mr. Municipal was appearing. Thereafter, he retired from the matter and fresh advocate, learned advocate was appointed.
For Badwan municipality?
No, my lord, from Memory College.
Memory College.
Memory College.
What is the dispute?
My lord, the dispute is this. My lord, I have been debarred from my service, my lord.
You have been?
I have been debarred from my service, and my service has been terminated in me. And before my lord comes to the impugned order, my lord, I'll be placing before your lordship. Your lordship will kindly come to this honorable court's order.
In the disciplinary proceedings,
There was
an
no
order.
disciplinary proceeding, my lord. At the whims of the principal, my lord.
No proceedings conducted.
He says that the departmental proceeding was initiated due to my misnotion, my lord. It was not required.
Due to?
Due to my notion was wrong. I had to file one, I had to make one disciplinary proceeding, but that is not required. And the state has said, that the disciplinary proceeding is required. State has supported me. My lord kindly sees, and the scope of the impugned order, my lord will kindly come to page 88 and 89. The previous writ application filed by the petitioner, and it was heard before this honorable court, and it was disposed. 89, it starts, my lord. The present writ petition has been preferred. Pardon, may I read? The present writ petition has been preferred, challenging internally as the denial on the part of the college authorities to allow the petitioner to resume his duties as a teacher in Bengali. Mr. Ganguly, learned advocate appearing for the petitioner, submits that the petitioner was appointed in the post of teacher in the year 2006. He was falsely implicated in a criminal proceeding while he was discharging his duties as a teacher in the Memory College, in short, the said college. A so-cause letter was issued to the petitioner by the respondent number 6 on 17th August 2018. Thereafter, a memo dated such and such. The respondent number 6, the petitioner was intimated you are deemed to have been suspended with effect from the date of your arrest, that is 21st September 2018. Thereafter, by memo dated such and such, the respondent 6, the petitioner was intimated internally as since the departmental proceeding could not be continued for his unauthorized absence, and there has been no information that the criminal case has been ended in acquittal, the competent authority feels it necessary to extend the period of suspension from duty for further 6 months with immediate effect. Mr. Ganguly submits that the criminal case, as referred to the impugned memo dated such and such, has already been disposed of by a judgment delivered on 6 September 2019. By the said judgment, the petitioner has found not guilty of the charges of the offences. The period of extension of the order of suspension, as referred to the memo dated such and such, has also expired, and as such, there exists no bar to allow the petitioner to resume the duty. Stating such facts and annexing the copy of the judgment, the petitioner.
So there was a direction to consider your representation for revoking or
My lord.
withdrawal of the suspension order.
Suspension order, my lord.
What
Page
has been done after that?
Thereafter, my lord, page 95. Page 95, and thereafter, I am placing this impugned order, and thereafter I will leave to place the facts. Rescind order passed in pursuant to the order dated such and such of the Honorable High Court passed in writ petition number 157W of 2020, Robin Kumar Majumdar versus State of West Bengal. The Robin Kumar Majumdar was a part-time teacher in Bengali in Memory College. Subsequently, he was termed as government approved part-time teacher. His service is renewable for every year subject to the approval of the state government. My lord, I beg to submit before my lord that there is no rule. The rule is otherwise. I will be submitting that later on. Renewable every year subject to approval of the state government. For a number of years, said Mr. Majumdar frequently used to be absent from his duty in the college. Notice was issued to Sri Majumdar asking for his explanation as to the fact of his frequent absence from duty, even on the examination date, without prior permission of the college authority. While submitting the explanation to such notice, Mr. Majumdar also tendered his apology for the inconvenience caused to the college. Several complaints were lodged against Sri Majumdar by the teaching and non-teaching staff of the college. As a temporary measure, the administration of the college debarred Sri Majumdar from academic and non-academic activities of the college and also stopped his payment of remuneration, which was, however, regularized subsequently. Criminal cases were also registered against Sri Majumdar on several charges, including that of moral turpitude. During such period, Sri Robin Kumar Majumdar moved a writ application dated such as number such and such, particularly challenging the order debarring the college activities and stoppage of remuneration. The college contested the case by filing an affidavit. When the said case was pending, Sri Majumdar was arrested by the police and taken into custody. An order of suspension was issued by the college authority. My lord, kindly see. Under wrong impression, the departmental proceeding was also contemplated against him. Under wrong impression. Such facts were brought to the notice of the Honorable Court, but ultimately the said petition was posted for hearing before the Honorable Court. Sri Majumdar repeatedly failed to attend the hearing and ultimately dated such and such, on order dated such and such, the Honorable Honorable Justice Tapobrata Chakraborty was pleased to dismiss the writ petition for default, the earlier writ petition, when I was in custody. In the said backdrop, notice was
But
sent.
in the earlier writ petition, you have challenged this order debarring you from attending the duties.
The classes and my stoppage of my salary.
Yes. So that writ petition was dismissed for default.
That writ petition was dismissed for default.
Yes.
Now that then I was in custody.
Yes.
In custody, and from after that, I was exonerated from the case. So I could not appear. It is a separate cause of action, my lord. And I have stated everything in my part of the prayer. I have stated everything in this writ petition, my lord.
Yes.
But I will be submitting to your lordship, my lord. So was pleased to dismiss the renewal for default. In the aforesaid backdrop, notice was sent to Sri Majumdar at his residential address on repeated occasion, asking his explanation for a prolonged absence from duty. Once notice was received on his behalf, on other occasions refused by the inmates of the house. It is stated earlier that service of all government approved part-time teachers of college are renewed by the competent authorities of the college on yearly basis. I deny, my lord. The names of such part-time teachers, if renewed by the college authority for the year, the names of the part-time teachers whose service are not renewed by the authority of the college for further year are struck off from rolls. The matter of renewal of the service of number of part-time teachers, PTT hereafter, was placed in the meeting of the college, authority of the college held on 7th December 2018 and 4th February 2019, considering the nature of the allegations labeled against Mr. Robin Kumar Majumdar from time to time and his prolonged absence from duty virtually from July
2018, the competent authority of the college did not think it necessary to renew his service for a further year 2019 to 2020, and accordingly did not renew his service for the financial year. His name was struck off from the roll of the PTTs and was not sent to the government along with the names of other PTTs. A copy of the minute prepared on this behalf in the meeting of the Memory College Authority was, however, sent to the Director of Public Instruction for his information. No document. A phrase read petition being WB number 157 of 2020 was moved by Mr. Majumdar before Honorable High Court, inter alia praying for direction for allowing him to join his service with all financial benefits by setting aside the order of suspension. From a copy of the order dated such and such, the Honorable Court, it appears that the undersigned was directed to consider the present representation of Sri Majumdar dated 7 November 2019, when I was exonerated from the criminal case. Consider the representation of Mr. appearing in page 66 of the petition. Upon giving an opportunity of hearing to the petitioner and to dispose of the same by reasoned order, notice was given to Sri Majumdar on 2nd March 2020. A hearing was given to Majumdar. Submissions made by him was heard, who claimed resumption of duty, resumption of his duty and payment of remunerations with effect from the date when Mr. Majumdar was absent from his duty. It could subsequently be ascertained that in the case of PTT, full-fledged departmental inquiry is not required. Is not required to be held in order to find out the cause of the unauthorized absence or prolonged absence from duty or indisciplined work. PTTs do not enjoy the rights, privileges as a full-time confirmed teaching staff. There was no necessity at all to complain or initiate any inquiry proceeding against Sri Majumdar for his prolonged unauthorized absence from duty or unsatisfactory service primarily found by the authority. The college authority has full liberty to weigh the service rendered by the PTT for the past period and to decide whether or not his year-bound service could be renewed for a further year or not. Admittedly, Sri Majumdar was continuously absent from duty July 2018. There I was rebarred. At that time I was rebarred. I was rebarred on 24th July 2018. I will show your lordship.
24th July 2018, you were debarred.
I was rebarred, my lord. I was rebarred. It will appear from later appearing in page 49, my lord. I will show it to your lordship.
Yes.
I was rebarred. During such long period, Sri Majumdar did not come to the Memory College, did not make any communication with the college authority, even did not make any reply to the notices sent to him from time to time. Although the fact of issuance of the notices was within his knowledge, Sri Majumdar did not feel it necessary to inform the college authority regarding his whereabouts during such period. His conduct during a long period caused immense suffering of the students of the college and also to the administration. The authority of the college was not satisfied with the service and conduct of Sri Robin Majumdar and accordingly did not renew his service for a further period of 1 year, that is 2019 to 2020. His name was accordingly struck off from the roll. It may be mentioned in this context that the fact of the disconnection of his service and striking his name from the roll of the PTTs was also duly sent to him through letter dated such and such, but was refused to be accepted by the inmates of his house. In the aforesaid scenario, there remains no scope to grant any relief to Sri Majumdar, prayed for his representative such and such, as his name has already been struck off from the roll. The reference is accordingly disposed of. The copy of the order may be sent to Sri Majumdar. This is the impugned order.
Mr. Banerjee, where is your appointment letter?
My lord. About it. But page P1 are my mark sheets and all things.
No. Appointment letter.
Appointment letter is P2, page 20, Page 31.
Page 31.
My lord. From the Director of Public Instruction, the undersigned is directed to forward the order dated such and such 511 EDN dated such and such 30th June 2011 in respect of the approval of the part-time teachers of your college for information and necessary action. Page 31.
Yes.
Page 32. Approval of engagement of part-time teachers in Memory College, Part 1. My lord, kindly cease. The undersigned is directed by the order of the governor to state the governor is pleased to approve the engagement of 31 part-time teachers in Memory College, District Part 1 for the academic session 2010 to 2011 as detailed in annexure. The benefits of the revised remuneration will be admissible to all part-time teachers having age up to age 60. The incremental benefits in the revised scheme of remuneration of the part-time teacher may be accorded as per relevant provisions of GO number 751 EDN CS dated such and such of the. Under this GO, I was appointed, my lord. So my service is up to the age of 60
So you are
years.
a part-time teacher and you will be entitled to serve the institution till your age of 60 years.
60 years. And subsequent, my lord, GOs have also been accompanying all the previous GOs that my service is up to the age of 60 years.
This GO says.
This GO says, and subsequent GOs also says. But I'll be subject.
These part-time teachers initially, they were appointed from 1 year. Then it was extended from time to time.
Pardon, your lordship.
Thereafter, the notification came that there is no necessity of renewing year to year. It will be continued up to the age of 60 years. These are the notifications.
My lord, my name is in the
difficulty on that. But your status is that of a part-time
teacher. No doubt, my lord.
But you will be entitled to serve the institution till your age of 60 years. Now, if the authority decides to terminate the service of a part-time teacher, whether a disciplinary inquiry as per the rules is required to be taken.
Required, my lord, is
Show
also
me that
required.
provision.
My before that, my lord, kindly see page 33. My
33.
Page 33, my lord, name appears in the first position.
Yes, yes. That your name appears, that you are teacher for 60
lord,
years,
my
no
lord.
difficulty. But your status is that of a part-time teacher.
My lord.
Whether a disciplinary inquiry is to be conducted for terminating the service of a part-time teacher.
My lord, I beg to file the affidavit in reply to the affidavit in opposition filed by respondent number 2, the state government.
Show me the rules, Mr.
My lord, I will be.
Affidavits will not improve.
They
Show
say,
me that part-time teacher for removal, for termination, an inquiry is to be conducted. Show me that from the law. How affidavits will improve this?
my lord, kindly comes to. I will be placing the relevant rules, my lord, before your lordship, my lord. First, my lord, kindly come
Where
to
is
page
that?
107 of the writ application.
107. You annex the rules.
Yes, my lord, memorandum, my lord.
107.
107, my lord. In Congress of the General Policy of the Government of West Bengal, the undersigned is directed to order the governor to say the following provisions will be applicable in respect of the contractual whole-time teachers of the state-aided non-government colleges, provided they possess qualification for such work with effect from 1st January 2011. Existing CWTTs in serving a particular department of the state government non-government colleges duly engaged through a selection process as per norms of the affiliating university will continue to remain engaged in the concerned college till they attain 60 years of age. Departments courses run on self-financing basis are not included in this scheme. Page 109, my lord, during the period of engagement, the service of such CWTTs may be terminated because of involvement in criminal case, misconduct, delinquency, incapacitation, or other culpable anomaly may be framed by time to time by the competent authority. Nothing in. Now your lordship kindly comes to the latest circular, my lord, and latest circular 2019 at page 110.
You will not place the last paragraph of page 109?
But I have placed, my lord.
109, last paragraph.
Last paragraph, my lord. During the period of engagement, the service of such CWTTs may be terminated because of involvement in criminal case, misconduct, delinquency, incapacitation, and other culpable offence may be framed from time to time by the competent authority. Government means state, my lord. By the competent authority means the state. The state has formulated the rules, and previous permission of the state government is necessary. No such permission has been taken. I will place before lordship. That is in page number 110, my lord. Kindly see.
110, yes.
My lord. The matter, these are latest, my lord.
Yes.
So far, I have all the regarding, I have downloaded all the document circulars, and this is the latest one. The matter of restructuring the service condition and other benefits of the government-approved part-time teachers, government-approved contractual whole-time teachers, and guest teachers in any nomenclature engaged in different government and government-aided colleges in the state of West Bengal up to 13/7/2019 was under active consideration of the state government for some time past. After careful consideration of the matter, the governor is hereby pleased to, in all supersession of all previous orders in this regard, to restructure the service condition along with the change of nomenclature of the aforesaid category of teachers commensurate with their qualification and period of service rendered in the following manner.
That you can straight away come to point number 7. I.
Page number 7.
111. Yes.
Both the above two categories of teachers, state-aided college and the category, will be allowed to continue their engagement till the age of 60 years. However, the service of the particular teacher of the above categories may be terminated by the governing body with the approval of the state government. There was no approval.
Only the relevant thing. Why were we?
My lord, I bow down to your lordship. No approval was taken. No approval was taken. Approval of the state government for non-performance, incapacitation, delinquency, misconduct, involvement of the criminal case and other culpable offences in such manner as may be prescribed by the state government. I bow down to your lordship. Thereafter, my salary structure and all the...
Mr. Banerjee, what you will do with the salary structure? The issue
no, my lord, issue is
termination. Why are you going to salary
no, my lord, no, I bow down. I extremely, my lord, I am placing the whole document before lordship. I will. This is the whole, my lord, my humble submission that no such. And if your lordship kindly comes to the affidavit in opposition and the reply, my lord, the state government has also said, paragraph 12, my lord.
The reply, state government has filed an affidavit.
State government has affidavit in reply, and my lord.
Respondent number 2.
Respondent number 2.
Yes. What did they say about this termination?
Sir. The state government says it was not intimated to them. Page paragraph 4, my lord. Paragraph 4, page 2. The instant decision of the college authority in relation to his teaching staff.
Paragraph 4.
Paragraph 4, my lord. Respondent number 2, my lord. Evidence in opposition, my lord.
Yes, yes.
The instant decision is of the college authority in relation to his teaching, and as such, in the instant case, the respondent number 1 and 2, being the higher secondary department, higher education department, and the directorate, has no direct involvement in the instant matter.
And what is the stand of the college?
college, I have placed the impugned order, my lord.
No,
It
they
is
have
not
filed an
required, my lord.
opposition, they have filed.
Opposition they have filed, my lord.
Yes, what is the stand in the
My lord.
opposition?
And my lord, I have stated in my reply that no approval was taken, my lord. Opposition, my lord. But the college faced severe difficulties for hooliganism created by the petitioner such as all. But this is the scope of the solemn order passed by this honorable court in the previous writ application. It was beyond the scope. In my humble submission, my lord, subject to my lord solemn observation, my lord, was registered against the petitioner accused Mukesh Sharma. His case has been withdrawn and he has been reinstated. In case of Mukesh Sharma, the another whose service was terminated.
He has been reinstated. Where is
Reinstated.
that?
But I'll be.
In this opposition, it has been stated.
My lord.
What can be done, Mr. Banerjee? Your client will not attend the college. What the college authorities do?
My lord, your lordship, kindly, my lord, I beg to submit, my lord, kindly cease. My lord, but he is a victim of situation or political things, my lord. My lord, if your lordship sees, my lord, if your lordship sees.
But the fact
Page
is, he did
34.
not attend the college.
But
that is so what the college can do.
This principal has given a number of certificates in my favor. This principal has given, Moheshata Devi has given a certificate in my favor. My lord, I have
taking advantage of that. You
no, my lord,
coming to college.
Stop coming to the college, my lord. I have not, but there was an operation for that time. I could not. I had a piles operation. That was I have annexed the.
You could have taken a medical leave.
Medical leave I have taken, my lord.
Yes.
And I have the prescriptions I have annexed in this writ application, my lord.
Yes.
And second time
So was that sanctioned? Medical leave, was that sanctioned?
They did not, my lord, sanction. They gave me that.
Did you apply for that?
Don't come to the college.
Mr. Banerjee, did you apply for that?
Yes, my lord. Subject to correction, my lord. But they say, my lord, I was debarred from entering the college. I'll be placing in my home.
That operation or something took place while you were debarred from attending the college, or for the other period.
My lord, kindly come to page 49, my lord.
Of the writ petition?
Writ petition, my lord.
Yes, page 49.
Page 49, my lord. As per decision arrived at the meeting held on 23rd July 2018, the administration of the Memory College has stopped your salary for an indefinite time. It is also to intimate you that you, Mr. Majumdar, hereby is barred from the college altogether, effective from now, from all kind of academic, non-academic activities of the member.
Where is the decision on the meeting held on 23rd of July?
There is no decision, my lord. This is the only communication made to me. One line order, my lord. And thereafter, my lord, for that period, I have given all prescription and certificates, my lord.
Show me that you have applied for medical leave. Show me the document that you have applied for medical leave.
My lord, kindly come to page 48, my lord. Answer to your so-called notice. This has reference to your letter such and such issued by me on 6 July 2020. Last date for me to answer this letter is 7th July 28. I would like to say that.
Mr. Banerjee, you did not apply for leave. Kindly come to page 48, reply to the show cause.
Yes, my lord.
You have said from 3rd of July to 2018 to 9th of March 2018. You are in severe pain for which you could not attend. I'm sorry for this.
I would
This
like
is your reply to the show cause notice.
the last date for me to answer the letter is such and such. I would like to say that I have been given a few more days to answer the letter. However, I
So 9 months you did not attend. Nothing. So you felt sorry for that in the reply to the show cause notice.
9 months.
From 3rd of July, kindly
3rd
come
of
to
July
page 48.
2018 to 9th of March.
Yes, so 9 months.
No, my lord, it is a typology mistake. 3rd September to both are 2018. Both are 2018, Martin. Both are 2018. I am a patient
these
of
two dates.
Both of 2018. And
On
these
2 dates.
on 2 dates, my lord, 2 dates. I am a patient of ice and I was in severe pain. Therefore, it was humanly not possible for me to attend the college. I am sorry for that, for this. 2 dates, my lord. 10th March 20, it was my off date. 10th April 2018, those dates were mentioned. I have given reply to these. 10th April 2018, I have taken casual leave.
Mr. Banerjee, kindly come to page 47.
47, my lord.
Purpose was, you have been away without any prior permission from the following dates. From the last B.Ed examination duty of 29th of January. From BA become BSc Part 2 test examination on 9th of March, 10th of March, and from BA BSc duties 10th of. So from these dates, and you have explained only these 4 days.
No, my lord, 9th March 20, 10th March 2018.
Did you inform them? Did you inform the authorities? You are given examination duty. You will not inform the authorities. You ought to have informed.
Inquisition date such and such as the principal's office holds documentation.
You remained absent without even informing them. And you are given the examination duty.
BA become invigilation duties.
What is from? So continuous period.
Invigilation duties. Dates are my humble permission would be. But dates are mentioned 10,
yes,
11,
from
16.
prior to the date, it is from. That is
Following
from
date
9th of March.
From the last B.Ed examination duty of 29th January 2018.
Thereafter, you did not attend.
BA.
Thereafter, from. The expression is from. That is the starting date. Till after that, you also did not attend. And you have explained the starting dates only. That too, without any information.
The time period for which the principal has mentioned in his order is regarding the date when I was debarred and I was under trial.
You was debarred on July, but this is of March. At that time, you were not debarred. And that was not your explanation also. Your explanation was that for certain reason I could not attend medical ground and I'm sorry for that. And this you have written on 7th of July. No prior intimation.
The letter date is 4th July 2018 and my reply was on 7th July 2018.
Yes. 7th July you are informing
reply,
that you did not attend for this reason and you are sorry for that.
But the intimation was on 4th July 2018.
Yes. Mr. Banerjee, yes. But you did not attend on 9th of March. You did not inform the authorities immediately.
Thereafter, I continued the service. Thereafter, I was in continuous service. Thereafter, I was in continuous service, my lord. Thereafter, all on a sudden, I was giving the notice. Thereafter, I was working there. All on a sudden, this show cause notice came and I was debarred. All on a sudden, my lord.
What was the criminal case for?
My lord kindly comes to.
What was the allegation?
The allegation is of a death of a girl, and I have annexed the judgment.
No, death of a girl means?
Of a, no. Possibly I have handed over to my lord a typed copy of this.
No, I want to know the allegation. What is the allegation against you? What was the allegation against you?
Well, I have to. There was a in custody trial and I was exonerated.
All right. Yes, anything more?
I was arrested on 21st August 2018, page 10, paragraph 14, and acquitted on 6th September 2019, para 12, page.
Arrested on
21st August 2018.
Allegation, what was the allegation?
Yes.
And acquitted on 6th September 2019.
Yes.
Paragraph 12, page 18.
Yes.
This was the and that the accused and no and the judgment, my lord, starts from page 79.
But place the judgment. The fact is that you are acquitted.
I am acquitted. I am acquitted. And I was a victim of circumstances. I have said, due to political rivalry, I was.
Want to submit? Want to submit anything more?
No, my lord.
Yes.
And I am on behalf of the respondent number 5 and 6.
College.
College, my lord.
Yes.
But as per my instruction, my lord, my irregular and the person, my lord, the petitioner, who was, my lord, irregular and absent from duty, causing suffering of students. Number 1. Number 2, my lord, petitioner.
What was the period of absence?
From 2018, my lord, from since 2018.
Continuous period.
Continuous.
Give me the period from which he was absent.
My lord, affidavit in opposition, my lord.
You have stated that. Which paragraph?
The so-called notices, my lord, starting from page 15.
1-5.
1-5-15, my lord.
Yes.
My lord, in page number 3, paragraph number C, D, and onwards, my lord, it is written.
Page number 3.
Page number 3, in paragraph it is written, and the annexure, my lord, is from 15, page number 15. The period of absence.
Number 15. 15 to so-called notice.
হ্যাঁ, শোকজ নোটিশটাই তো বলছি যে কোন সময় থেকে অ্যাবসেন্ট করলো from July of 2018, my lord.
This was the show cause notice.
Yes, my lord.
17th of August. What is the reply?
There is no reply, my lord. He has not bothered to reply. Then only my lord, he was suspended. As he was absent without any information and reply. This is, my lord, regarding absence. The petitioner also, my lord, assaulted other teachers, including the lady teachers, my lord, of the college. And college, my lord, because of his hooliganism, my lord, lodged complaint against the petitioner in Memory Police Station, which is, as per instruction, is still pending and not dissolved. Considering his attitude, my lord, his name was struck off from the role of GAPTT. And due to COVID, my lord, the notice could not be served. And after COVID, my lord, notice served to him. It was the instruction, my lord. And the service of petitioner, my lord, was renewable every year subject to the satisfaction of the college, my lord, college authority, college administration. And considering petitioner's prolonged unauthorized absence from duty, college authority had not renewed his service, my lord. This is also my instruction.
Yes. Anything more?
No, my lord, nothing more. This is instruction only. This is only instruction, my lord. This instruction I have only received.
What is your submission on? Kindly come to the writ petition. Page 110. You have got a memorandum at page 110. Kindly turn over to page 111. Point number 7, clause III. Kindly place that clause.
Page number 111 is not there, my lord. 110 and then 112, my lord.
Mr. Banerjee, you have not given
No, my
the-
lord. Mr.
Kindly
Position was appearing.
10, 12, sir. 11 is not there.
Mr. Dole, you are appearing for the state. You are having page 111.
Yeah. My lord, it is here.
It is there.
It is here, my lord. Yes, my lord, it is here.
It is number does
Number does not change it. Correction, it is 11.
11 হবে।
Page is continuous, but the
9
লাইন থেকে একটা করে কেটে এটা চেঞ্জ হয়েছে একটা করে পরে ইয়ে হয়েছে হ্যাঁ ঠিক
The old designation is, my lord, what he says, one page is after that.
So you have got that memorandum. Kindly come to clause 7 III.
7.
This is a state aided college.
Why not? State aided college.
Have you seen that? Place that clause.
Misconduct is also there, my lord.
Yes. But what is the procedure for termination? Kindly read this memorandum. Have you obtained the approval of the government?
My lord.
Show me that you have obtained the approval of the government for terminating.
My lord, beg to be pardoned. My lord was inquiring from me regarding the other case, Mukesh Sharma case. My lord. But page 2, my lord, Mr. Monish Sen, learned advocate, it starts. Page 3, my lord.
But Mr. Banerjee, this decision did not take into consideration that memorandum.
Not taken money. Money was not taken consideration.
So,
Pardon, my lord?
are you relying upon the Burdwan University service rules?
No,
Or
my
you are
lord, no,
relying
my
upon
lord,
this
no, no.
memorandum?
But I am governed by
This
this.
decision proceeded on the Burdwan University service
My
rules,
my lord,
the procedure for termination.
my lord,
You
that
have
can't
to
be. No, my lord.
make your stand clear.
No, my lord,
If you want to
no, my lord,
proceed,
no, my lord. No, my lord.
you are not relying on
Not
this,
yet.
then take it back. Yes, have you followed this procedure? Have you taken approval of the government?
My lord, in page number 23, my lord, of the affidavit in opposition, it is only
23.
23, my lord. It is only seen, I can see, my lord, the administrator of Memory College, my lord, has signed. Except the principal. সেখানে লিখেছে যে কেন কাজ
And the ground for termination is service was not satisfactory. He was in police custody and his long absence since 21st of August 2018. At that time, he was in custody, not prior period. From the date of his arrest against, and the college authority also lost an FIR. So this is the decision of the administrative authority for termination. Yes, Mr. Dole.
But before my learned senior friend might make submission, my lord, one thing in my the affidavit of the one thing I forgot to point
Affidavit
out,
of?
Your Lordship, page 7 of the Mr. Dhole's opposition, my lord. Page paragraph 17, page 7. With regard to the statements made in paragraph 17 of the writ petition, I say that it is for the college authority to disclose before the honorable court as
Page,
to
page,
whether page, my lord, 7.
7, paragraph.
Paragraph 17, my lord.
Yes.
With regard to the statements made in paragraph 17 of the writ petition, I say that it is for the college authority to disclose before the honorable court as to whether disciplinary proceeding was initiated against the petitioner or not. This is the rule. It is the stand of the state. And the principal says it is not required.
Yes. Yes, madam, you want to submit anything more?
Well, I think I need to take instruction, my lord.
What instructions after affidavits?
If I
Yes.
collect, my lord, any further document, my lord.
Yes, Mr. Dole.
But the thing is that, my lord,
Mr. Dole, kindly come this side, kindly use the microphone.
My lord has referred to the my lord notification. My lord kindly sees the notification.
That memorandum.
Memorandum. That is at page 111. My lord has my lord, it is pointed out that terminated by the governing body with the approval of the state government for non-performance. My lord, the first, these are all, my lord, separate non-performance, incapacitation, delinquency, misconduct, involvement in any criminal case or other culpable offense as the matter may be prescribed by the government. So, my lord, all these, my lord, criterias are, my lord, present in the instant case because my lord has seen
So,
that.
Mr. Dole, the approval of the government is necessary.
Lord, that has not been disclosed as far by.
That is the, if that has not been disclosed, end of the matter. Memorandum says yes, those grounds are there. Maybe even if it is accepted, that in this case those grounds are present. But whether that can be done without the approval, or is it not your approval necessary for terminating?
Yes, my lord, according to the memorandum, it's necessary. So, my lord, whether, my lord, it is not disclosed even, my lord, by the college authorities. My lord, what I'm, my lord, pressing before your lordship that
They have not taken any permission. It is as simple as that. They have not taken any approval. Because if they have taken approval, they would have disclosed that document. And if you kindly come to the opposition of the college. The decision or order passed for termination.
yes,
Page 23, have you got that?
my lord, page 23.
Of the college, of the affidavit of the college.
Yes.
So kindly read the last paragraph.
This is to be noted that serial number 1, GAPTT Sri Robin Mojumdar, Department of Bengali, be struck off from the role of GAPTT. His service has been unsatisfactory and Mr. Mojumdar has been in police custody in connection with a criminal case under section 376 IPC, was deemed to have been suspended by order dated 11/9/2019 and with under addendum number 3 of administrative meeting dated 7/12/2018. My lord, 18, in charge of grievous misconducts and misdemeanor. The principal is to cancel his approval for current session in connection with his absence from the college since 21/8/2018. So, my lord, it's prior to the notification. Probably it's in
21st of August 2018 is the date of his arrest.
Yeah.
So how can he attend that?
My lord, this is
He has
prior.
been acquitted, Mr. Dole.
My lord.
The ground is that he did not attend. Admittedly, he was arrested in connection with a criminal case. Subsequently, he has been acquitted.
My lord.
In that case, that is the ground.
My lord. Then,
And
my lord,
from the date of his arrest, and other thing is that college lodged an FIR. Nothing, only lodging of an FIR is neither here nor there.
my lord, now my submission is, my lord, kindly comes to page 109 of the memorandum again.
Yes. 109.
And that is, my lord, probably 110 of
All right,
your
yes.
lordship's page.
23rd December 2019.
And my lord, kindly sees the date. Date, my lord, he was, my lord, my lord, absent. It is 7th of December 2018. Prior to coming into effect of this notification.
No, the order was of termination was on. What is the date?
4/2, my lord, probably 4/2/2019. My lord, last.
4/2/2019.
Yes.
What was the procedure prior to this?
So, my lord.
What was the procedure for termination prior to this?
That I have to take instruction.
You are the state, Mr. Dole.
Yes, my lord, I know, my lord, but here I am, my lord, also led by the Tapan Kumar Mukherjee, my lord, this matter. My lord, এর আগে কি ছিল? কারণ এইটা তো অ্যাপ্লিকেবল হবে না, কারণ আমাদের টার্মিনেশন তার আগে হয়ে গেছে।
Yes, Mr. Banerjee.
Yeah.
The memorandum is a subsequent memorandum. That cannot be given effect to that. This was dated.
But in that memorandum, my lord, of 2010, my lord, there was no nothing regarding year-to-year renewal, my lord. If your lordship
No,
kindly
not
sees-
year to year, but termination. Termination with approval. Where is it?
My lord, he will be entitled to gratuity when he attains the age of 60. My service is continuous up to the age of 60.
It's not that, Mr. Banerjee, even if there is misconduct, you have to be allowed to continue till 60.
My lord, there
How can a service of such a part-time teacher be terminated prior to this memorandum? What is the procedure?
but the matter
এটা দিয়েছে আমার ইয়েটা আমি খুঁজে পাচ্ছি না এফিডেভিটটা
in supersession of all, my lord, previous circulars, my lord, these 2019, my lord, circular has been.
Mr. Banerjee, when it was superseded? Superseded on a date subsequent to your termination. So the earlier circular will govern your case, not this one. From the date of issuance, the previous circulars are superseded.
During the period, the service may be terminated because of involvement in such and such, matter, page 109, my lord. Delinquency, incapacitation, and other corporate offences as may be framed from time to by the competent authority by the state. But it was not framed, my lord.
Yes. Then how does it help you? If it is not framed, then
my
can
lord,
be terminated.
in ipso facto, they cannot, my lord, they have to take the permission of the ratified by the
Where
state
do you
government.
get that, Mr. Banerjee? They have to take the permission. Where is there?
Because in my humble submission, my lord, subject to my lord solemn observation, my lord, my service is up to the age of 60 years. I was in custody. I was acquitted.
There is misconduct. They have to allow you to.
My lord, no, my lord. The scope of the earlier writ petition was I was acquitted and I may be allowed to join.
I have followed that. I'm asking you what is the procedure for termination of a part-time teacher?
The state says in its affidavit that there must be a departmental proceeding. It is for the college authority to disclose whether there was any departmental proceeding or not. They have in the affidavit they have stated. They have stated, my lord. The state has stated.
State's affidavit on that is neither here nor there. You cannot. I've seen that. You have placed that.
College authority to disclose before this court. Not must. I have not stated.
And they said that it is not.
Where is who is appearing for Burdwan Municipality? Burdwan University. Burdwan University is a party. This college is under Burdwan University.
Burdwan University, my lord.
Who is appearing for Burdwan University?
ওইটাতে কে অ্যাপিয়ার করেছে আপনি দেখুন না আগের একটা অর্ডার দেখাচ্ছিলেন অর্ডারটা কে অ্যাপিয়ার করেছে
আসুন
Nobody appeared, my lord, in the matter.
নিন আপনার ইয়েটা কিন্তু আমাকে একটা ডকুমেন্ট আমাকে
the issue involved in this writ petition is whether the approval of the state government is necessary for termination of a service of a part-time teacher of memory college, which, according to the petitioner, is a state-aided college. First up. Mr. Banerjee, learned advocate appearing for the petitioner, places reliance upon a memorandum dated 23rd of February, 23rd of December 2019, in support of his contention that the service of a part-time teacher of a state-aided college can be terminated by the governing body only with the approval of the state government. Paragraph. Mr. Dole, learned advocate appearing for the state, submits that the service of the petitioner was terminated on by an order passed by the college authority in a meeting held on 4th of December 2019.
December? No. 4th of February, my
Sorry,
lord.
4th of February 2019.
Page 111, point number 5, my lord. After
Page
111.
Yes.
The benefit of this order shall be allowed to part-time teachers, contractual, whole-time teachers, and guest teachers who are engaged in the college on or before 13th July 2019. And my order, there was no order of termination. My name was struck off from the rules. There was no order of my termination. Simply struck off from the rules.
By an order dated 4th of February 2019. Mr. Dole submits that the memorandum dated 23rd of December 2019, therefore, cannot come to the aid of the petitioner. Full stop. On a query of the court as to the procedure for termination of the service of a part-time teacher of a state-aided college, prior to issuance of the memorandum dated 23rd of December 2019. না কি বলে শুরু করলাম ওনা হ্যাঁ Mr. Dole prayed for an accommodation to assist this court on the next occasion. Full stop. The learned advocate for the state shall produce the relevant memorandum which were governing the field at the relevant point of time with regard to the procedure for termination of service of a part-time teacher of a state-aided college on the next date. Stop. List this matter on in the next week under the heading continuing matter. আচ্ছা একটা লিখুন affidavit in reply to the affidavit in opposition filed by the state is taken on record. ওটা একদম উপরে করে দেবেন. Yes, next.
45. 45, I'm for the private respondent.
I'm for the petitioner, my lord. This matter relates to unauthorized construction under the West Bengal Municipal Act.
Unauthorized construction on a municipal land.
West Bengal Municipal Act. Under the West Bengal. No, my lord.
You want to demolish that unauthorized construction?
Yes. And order was passed. Kindly comes to page 31. Page 31, my lord, I'm reading out, my lord, from the second paragraph of the last page. The complainant Manasi Rai also submitted few documents from which it appears that a title suit being numbered such and such has been filed, alleging encroachment, wherein disputed area was mentioned as A1 scheduled property, which is situated on the northern side of A scheduled property, owned by the petitioner, and the disputed property is situated on the southern side of B scheduled property, owned by Kusumrani. The suit is pending for adjudication. Heard considered the representation and the prayer. A case of unauthorized construction is clearly made out. Whatever explanation might be offered for such construction, it is evident that the disputed construction is made without any plan sanctioned by this municipality. Hence, it is a fit case for invoking section 218 of the Municipal Act for demolition of the disputed construction. I am not unmindful of the fact that part of the disputed premises is also the subject matter in title suit number 171 of 2017 before the civil court. But also it will not be prudent to execute the demolition right now, as that may give birth to such other disputes between the parties and may also hamper the merit of the case. Here I am aggrieved, my lord.
Who has
This-
filed a civil suit?
I myself has,
Give me a plaint.
My lord, on the last occasion, the plaint.
on
was
the last
taken on-
occasion,
Give me a plaint.
My lord, here's the copy. It's already taken on record on the last date.
It was taken on record.
My lord, even the order sheet, there was an order of status quo which was passed.
yes.
On the last date, my
All right,
learned friend had sought
Yes,
time to
yes.
take instruction.
Title suit
regarding-
number 171 of 2017.
My lord, kindly see.
Give me a minute, Mr. Rai.
My lord,
Give me a minute. Let me
Lord.
go through the plaint. Hurriedly go through the plaint once.
lordship.
Yes.
Now, my lord, kindly, if your lordship desires to see the order of status quo, my lord, I can also. Municipality is not a party. Subject matter of the suit and cause of action of the suit is completely different from this writ petition. There, my lord, the subject matter is the encroachment, which doesn't come within the domain of the municipality. Municipality cannot decide on the question of title. I relied upon an authority on the last occasion, my lord, that is with your lordship's file, my lord. If not, my lord, I can again, my lord, place it. And there are other judgments, because what had caused disturbance to your lordship was that, my lord, the status quo order. On that point also, my lord, I am prepared today. Now, my lord, if
According to you, in the enclosed portion, this illegal construction has come up.
yes, and my lord, the suit, my lord,
What is the unauthorized construction according to you?
my lord, total building is without sanctioned plan. My lord, the
Total building.
one thing is, my lord, kindly seize the impugned order. My lord, there are my lord, two aspects over there, my lord.
Yes.
So far as, my lord, the municipal law is concerned, My lord, if there is any whistleblower, my lord, about an illegal construction, my lord, the authority is to act. So, my lord, here, my lord, admittedly, my lord, my learned friend also on the last occasion, my lord, admitted, my lord, that they didn't have any, they doesn't have any sanction plan and the building is illegal, and that is the finding of the municipality also. Now, the question is, my lord, since the suit is pending, so municipality said, so therefore, we will not proceed since matter is sub judice. There, my lord, my contention is that, my lord, the suit cannot stand in the way of the municipality in exercising or its territorial duties. They are bound to, my lord, comply with the statute, my lord. It is their duty to, my lord, to get rid of the illegal constructions.
So in an indirect manner, it will get
No.
rid of the suit.
No, my lord, on this
Encroach portion, demolition.
Encroachment is something else. My lord, on this point, my lord, if the law
Encroachment is by way of illegal construction, Mr. Rai.
illegal construction with the sanction plan, encroachment is something else.
The encroachment is by way of an illegal construction. I'm saying that.
Yes. So,
if that is demolished,
no, your lord,
you instituted a suit.
I have instituted a suit because
prior to the institution of the suit, someone advised your client to move before the executive magistrate. 144 was.
Your lordship had vast experience, my lord, on this thing. I am not.
Admission in the plaint. Mr. Rai, admission in the plaint.
Yes.
Your client first went to some advocate. He instructed to file 144. Executive magistrate. He approached. Then thought it fit. No, it will not serve his purpose. Then approached the civil court for removal of encroachment. Then someone gave in advice. It also may not serve some purpose. Then make a complaint to the municipality alleging an illegal construction, approach the reached court.
Now, my lord, the question is
to withdraw your suit.
My lord, kindly, my lord, appreciate.
I
will withdraw my suit, my lord, subject to your lordship. My lord, let my lord
withdraw your suit.
Let me be allowed. Let me be allowed to, my lord, place
withdraw your suit, Mr. Rai.
If your lordship kindly, my lord, I will withdraw the suit. Your lordship may dismiss my writ petition. My lord, kindly allow me to place my case in my own way.
Conscious decision which you have to take. If you withdraw your suit, yes, my lord, because some part of the cause of action.
My lord, the legal position. So far as the legal position, may I be allowed to place? Then, my lord, I will bow down before your lordship.
Then I will decide on merits, Mr. Rai. I will not allow you to.
Yes, yes. Your lordship may dismiss my case also. Now, my lord, the cause of action of the suit, if your lordship sees, my lord, the suit is, my lord, for encroachment. It's a suit for declaration. Your lordship knows. Municipality is not a party. There the cause of action is completely different. That my plot has been A1 has been encroached, which is my plot, and they are claiming it within a part of A. That is the suit. Now there, my lord, I have sought for a declaration of my right, title, and interest. Now, my lord, so far as the writ petition is concerned, here, my lord, my allegation is illegal construction, adjacent neighbor. My lord, under the law, under section 218, if there is an allegation of unauthorized construction, municipality is to act. Now, unauthorized construction, municipality is to see.
You have a copy of the West Bengal Municipal?
Yes, please.
Give me.
There is an alternative remedy also available under section
218 subsection 3.
Yes, that is an appeal.
Go before that.
Appeal. Appeal is, my lord, I have.
Go before that.
I urged on this point, your lordship was satisfied on the last occasion that,
Go
my lord,
that.
if I am. Plan nahi. Now, my lord, kindly sees what is the language of this statute, 218. My lord, I can only go against an order of demolition. Here, my lord, I am not aggrieved with.
Only against an order of demolition.
I am not aggrieved with the order of demolition. I am aggrieved with.
How do you say so?
My lord, 218 starts, my lord, the caption starts order for demolition or alteration of buildings in certain. Now, my lord, 218(1) says if the Board of Councillors is satisfied that the erection of any building has been commenced without obtaining sanction or permission under the law, or is being carried on or has been completed otherwise than in accordance with the particulars on which such sanction or permission was based, or after such sanction or permission has been lawfully withdrawn, or is being carried on or has been completed in breach of any provision contained in the Act or in the schedule or in any rule or rules, regulations or that any building or projection exists in violation of any condition, direction, or requisition lawfully given or made under this act or the rules or the regulations.
Rai is the order
Lordship,
passed by the councillors which
Board of
is
Council.
impugned is not under 218.
It is under 218, it is an order of demolition. My lord, it is an order of demolition.
Yes, it's an order of demolition.
And
it is an order of demolition.
Demolition.
Yes.
Now, my lord, I am, my lord, not agreed with the order of demolition. Now they have restrained the implementation.
You want liberty to approach or you don't want liberty to approach?
No, my lord, kindly, my lord, if you
want liberty, I will give liberty.
Liberty to approach, my lord, I
280 subsection 3, you have to take recourses to 218.
Now, in that event, your lordship will have to clarify or decide, my lord, that this 218(3) lies even in this case. Then your lordship hold.
You argue, I will decide that.
No,
decide that.
My submission is that, my lord, 218(3), my lord, no appeal lies, my lord, in this case.
Yes, why?
Now, because, my lord, this is
an order of demolition.
This is an order of demolition, but I am not agreed by that. I cannot file. I cannot prefer an appeal against an order of demolition which is at my instance.
So you are not aggrieved by the impugned order. Why have you filed the writ petition?
I am aggrieved with the last portion which is patent illegal.
So you are aggrieved by that.
No, then your lordship will kindly, your lordship will, if your lordship keeps it open, then my lord, I will be nowhere. If your lord, my lord, I will bow down before your lordship. If your lordship decides that even in this case, if he is aggrieved by that portion also, he is to prefer the appeal.
I will clarify everything.
No, my lord, because I have authorities to show. Why I am saying so, my lord, even
the petitioner, who is the adjacent landowner of the private respondent, has filed this writ petition praying for.
My lord, may I be, my lord, your lordship didn't allow me to, my lord, place the other authorities. My lord, in those cases also, I will be, my lord,
make submission.
Because, my lord, in similar factual circumstances, my lord, there are authorities, my lord, which I had collected in my limited knowledge. Your lordship may not be satisfied, but may be allowed to place only those authorities. Where, my lord, these facts are also, my lord, more or less similar. Yeah, well, this is the paragraph 6, my lord. May I take your lordship to paragraph 6? The second issue is with regard to the order of injunction passed. 6.
Yes.
Page 2. Well, lord, here, my lord, the appellants are the owners of the premises. If your lordship sees, my lord, the facts of the case also.
No, I am not on that.
I am the, kindly.
I am not on that. Whether the status quo order.
No, the factual is
that. 218 subsection 3, you approach there, trash out there. This is on whether the status quo order will come in the way. I'm not going to that.
And this is also, my lord.
I'm not in that. I'm only on alternative remedy.
My lord, here, my lord, the alternative remedy was not availed. Here also, my lord, the alternative remedy was not availed. Kindly says the.
That is a different thing altogether. It's the discretion of the court.
No, my lord, the
availability of an alternative remedy, whether the writ petition will be entertained, is the discretion of the court.
Writ petition was.
These facts, I will give reasons why I will not exercise.
Yes, that is what, my lord.
I will give reasons for that.
This locus standi to maintain the writ petition, my lord, that has been, my lord, agitated in this.
Locus standi is there. I'm not saying that you do not have a locus standi to challenge the order, but where?
Yes, that has been decided.
That I will decide.
That has been decided in this judgment, my lord, kindly.
Yes. Alternative remedy was considered.
No, since if your lordship is
alternative remedy was considered.
My lord, kindly cease.
Mr. Raj, show me that the alternative remedy by way of an appeal was considered. Paragraph 7 is the distinction, Mr. Rai. There no notice was served.
And that was that is Calcutta Corporation, but I am coming to other judgments, my lord. I have, my lord, if you kindly allow me, my lord. I have, my lord, under the West Bengal Municipal Corporation also, my lord, I have.
Mr. Rai, if there is a violation of the principles of natural justice, yes, alternative remedy is not a bar. You have not made out that case. That
No,
is
I
not
have
your
made
case.
the case that, my lord, this municipality, this portion of the order municipality is patent illegality and absolutely perverse and is beyond its jurisdiction. Under the statute,
that can be,
when
that point
280
can be asked also in appeal.
in 200, no, that
You cannot ask that point
my lord,
in
the
appeal.
jurisdiction of the municipal authority, my lord, on the merits of the demolition, my lord, the appeal will lie. But, my lord, so far as whether the municipality has
On the merits of the appeal.
no, because, my lord, they says that this is a demolition order, my lord, there is no dispute.
You will be having another round after 218.
No, round will only benefit them.
Will ultimately come
round
to
will
the High Court. So,
if your lordship, my lord,
in the meantime,
the position of law.
yes, position of law, yes.
May I be allowed to urge, my lord? Your lordship is getting irritated, annoyed, my lord.
Not annoyed. Not annoyed. You urge
I
your
have
point.
full faith on your lordship.
Not a question of annoyance. Why I will be getting annoyed?
No, my humble submission was that, my lord, in this type of cases.
If you want to rely upon any decision, give me that. For what proposition? First cite the proposition, then hand over the decision.
May I take your lordship, my lord?
What is the proposition, Mr. Rai? You are citing a
Proposition is
decision.
that, my
For
lord,
what
here, my lord,
proposition?
at the complainant, my lord, at the instance of the complainant, order was passed for demolition. That demolition order was not implemented. Citing the injunction, they preferred a writ petition.
That is not the
They
fact
preferred a
here.
writ petition.
Yes.
They
That is
did
not the fact here.
They did not prefer any appeal under 218(3).
That point was urged with
Yes,
regard
that
to
is what, my
alternative
lord, I am
remedy.
saying. Because the law. I shall come back on the next day.
No, no, no. Not on the next day. I will forget everything.
No, this is, my lord, since, my lord, it is.
My lord, there's
This
a
is for
judgment.
KMC.
Our division bench on this point, my lord, where even an order refusing demolition, my lord, section 218, subsection 3 lies. Here, my lord, there was an order refusing to demolish.
The section says an order under section 280. Order will be either allowing or refusing.
Yes, your lordship will kindly clarify that.
This is an order
Because otherwise,
passed
my
by
lord,
the division bench.
Here. It's clear. I will clarify that.
yes, my lord.
And I have also got hold
Because
of.
I have, my lord, I have gone through some judgments, my lord, where it has been held that since it is not parties are not aggrieved by the demolition, the writ petition will lie. I have some authorities, my lord, where I have seen, my lord, that since the party has not come up being aggrieved by the demolition order, so therefore this writ petition is maintainable. So that is what is bothering me. But since your lordship, my lord, if your lordship, my lord, clarifies that point, my lord, I will not have any difficulty to go on to the merits of the appeal under 218(3). But otherwise, my lord, I will be in a difficulty.
Sir, come to the paid portion, my lord. Come to this paid portion. Paid B. Nature of mandamus command responding municipal authority to modify and of cost to modify.
Yes, Mr. Rai, what order you are trying to cite?
No, my lord, these are.
No, cite the decision.
My lord, I have placed the decisions.
Otherwise, you will say, no,
I will never say, my lord, I am the last person to say all those things, my lord, at least before this court. I will never say. My lord, here, my lord, if your lordship sees the judgment starts with the line, the present writ petition is in essence to implement the order of demolition.
Yes.
And my lord, this demolition order was not implemented. My lord, if your lordship sees admittedly the appropriate authority proceeded in terms of the said direction, and it would not be wrong to record that the private respondent did not challenge.
Sir, here the case was the petitioner approached for implementation of an
Yes.
order of demolition.
I have also in this writ petition.
You want that? I'm granting that. I'm granting that order of demolition which has been passed by the municipality. Say so, I am allowing your
That is my
repetition,
prayer. Kindly see
directing them,
I have, my lord, kindly seize the prayer.
yes, yes, I am implementing, I am directing them to implement as it is.
No, as it is, my lord,
Implementation has to be as it is.
of the demolition,
Yeah,
of the demolition order, my lord, but the demolition order, thereafter it is the rider. If your lordship says,
then you are challenging. Then it's not implementation.
well, I leave it to your lordship. My lord, your lordship will pass necessary order.
Then it's
Your
not
lordship has,
implementation.
I leave it to your lordship. I shall not trouble your lordship anymore.
Any other decisions?
No, I
That's
shall
right.
not trouble your lordship anymore, my lord. Your lordship, my lord, your lordship had got the facts. Your
The
lordship,
petitioner who is an adjoining landowner of the
is the one those.
no, the petitioner alleges that the private respondent who is the adjoining landowner has raised an illegal construction by encroaching upon the property of the petitioner. Full stop. The petitioner filed a suit being title suit number 171 of 2017 before the learned civil judge within bracket junior division bracket close second court at Bardwan for a decree for permanent injunction restraining the defendant and their men and agents from interfering with the peaceful right, title, interest, and possession of the plaintiff, that is the petitioner herein, in respect of A and A1 scheduled property. Upon declaration of the plaintiff's title thereto. The petitioner in the said suit also prayed for a decree for declaration to the effect that A1 scheduled property is part and parcel of the A scheduled property, and for a further declaration that A1 scheduled property never pertains to the B scheduled property. It is not in dispute that the learned civil judge, junior within bracket junior division, second court at Bardwan, by an order being number 15 dated 8th of January 2018, directed both the parties to maintain status quo as regards nature, character and possession over Schedule A1 property in the light of the report of the commissioner, which was
not a party. In the suit, municipality is not a party.
in the light of the report of the commissioner, which was filed in the said titles. Since the municipal authority was not, the petitioner lodged a complaint before the municipal authority alleging that the private respondent herein has made a construction without obtaining any sanctioned plan from the municipal authority. The chairperson, Board of Administrators, Bardwan Municipality, Why the Board of Councillors was dissolved at that point of time? The chairperson,
It was during the COVID period.
Board of Administrators, Bardwan Municipality passed an order on 2nd of September 2021 directing the private respondent herein to demolish the entire unauthorized constructions, but the same will be directed now, with a further direction, then that the same will be executable only after the disposal of the civil suit pending between the parties. Full stop. Paragraph. Since the municipal authority was not a party to the civil suit and the status quo order was not binding upon the, I'm giving all the reasonings, and since the order of status quo was not binding upon the municipal authority, the petitioner chose to file an application under Article 226 of the Constitution of India, praying for modification of the order dated 2nd of September 2021.
Implementation of the demolition upon modification.
In paragraph 10 of the writ petition, the petitioner has specifically stated that the petitioner is aggrieved by the order of the municipality dated 2nd of September 2021. Full stop. It is paragraph. Mr. Royal Honored Advocate.
Paragraph 10, my lord, my language was different. My lord, if you allow-
Paragraph 10, you are not aggrieved.
No, kindly, my language was not, my lord,
Yes.
being dissatisfied with the impugned order, it was not there.
Impugned action.
The action.
Impugned action.
Not only impugned, what was not there? Kindly excuse me.
Inaction on the part of the respondent authorities. Acha, ওটা কেটে দিই কি বললাম ওটা কি বললাম in paragraph 10 of the writ petition, it has been stated that the petitioner is aggrieved by the inaction on the part of the respondent authorities. Full stop. Mr. Royal Honored Advocate appearing for the petitioner submits that since the petitioner is not aggrieved by the order of demolition, the order impugned in this writ petition is not an appellable one under section 218 within bracket 3 of the West Bengal Municipal Act 1993. He submits that the petitioner has approached this court for implementation of the order of demolition and has not challenged the order of demolition, and therefore, the petitioner should not be relegated to the forum provided under subsection 3 of section 218 of the 1993 Act. Section 218 subsection 3 of the 1993 Act states that an appeal against an order made by the Board of Councillors in this behalf shall lie with the court having jurisdiction. Full stop. an order of demolition was passed by the authority of the municipality, by the competent authority of the municipality for demolition, and the petitioner has prayed for modification of such order, as would be evident from the relief claimed in prayer small b of the writ petition, which runs thus. বলে ড্যাশ দিয়ে সেট আউট করে দেবেন একদম প্রেয়ার বিটা। Thus, page number 10 থেকে 11. Thus, it is evident that the petitioner is aggrieved by the said order, which is undoubtedly an order of demolition. The Honorable Division Bench in
But on the last occasion also, my lord, your lordship has the copy of the judgment I gave, my lord, AIR 1988. That is also there, my lord.
the Honorable Division Bench in MAT 1166 of 2021 in the case of Krishnendu Rai versus State of West Bengal and others, delivered on 18th of January 2022, after noting that the existence of an efficacious alternative remedy is not an absolute bar to the maintainability of the writ petition, was of the view that since section 218 within bracket 3 of the 1993 Act provides an efficacious alternative remedy, an aggrieved party has to approach the forum contemplated by section 218 within bracket 3 of the 1993 Act. Full stop. The petitioner could not make out any case. No, it is not the case of the petitioners that the exceptions under which an application under Article 226 of the Constitution of India can be entertained even can be entertained on account of existence of alternative remedy has not been made out. In view thereof, this court is not inclined to exercise discretion in favor of the writ petitioner. This writ petition is therefore disposed of with liberty to the petitioner to approach the forum contemplated under section 218 within bracket 3 of the 1993 Act. Paragraph. अच्छा
My lord, the other authority, my lord, I had given on the last occasion, it is not
তার আগে লিখে দিন
AIR 1988. It is with your lordship, my lord.
the learned advocate appearing for the petitioner places reliance upon the decision of the coordinate benches in the case of Shanti De and another versus State of West Bengal and others, and no, a coordinate bench extra. Coordinate bench and the decision of the division, honorable division bench
Lordship.
in the case of Shamsundra Mishra and others versus Radha Krishna Tiwari and others. বলে particulars গুলো লিখে দেবেন WP number and এত in Shanti De Supra, the petitioner approached the writ court. The petitioner therein approached the writ court with a prayer for implementation of the order of demolition passed by the competent authority. In the case on hand, the petitioner has prayed for modification of the order of demolition passed by the competent authority. The said decision being distinguishable on facts cannot come to the aid of the petitioner. In Shamsundar Mishra Supra, the Honorable Division Bench took note of the fact that no notice was served upon the appellants therein. It is well settled that for violation of the principles of natural justice, the writ court can interfere even if there is an existence of an alternative and efficacious remedy. The said decision being distinguishable on facts also cannot come to the aid of the petitioner. In the case on hand, yes, what was the other judgment?
My lord, the AIR 1988, I had given on the last occasion also. That is
for what proposition?
My lord, the pendency of the suit, my lord, and the writ petition, my lord, is not a bar. Even if the suit is pending, writ petition, my lord, will lie. Since the cause of
petition is
maintainable.
What is the decision?
My lord, AIR 1988, Calcutta 370.
You have a copy of that?
Yes, I have.
Give me
paragraph 6. Paragraph 6, my lord.
Mr. Rai also places reliance upon a decision of the Honorable Division Bench in the case of Rampuria Brothers Private Limited versus Calcutta Municipal Corporation, reported at AIR 1988, Calcutta 370, in support of his contention that a writ petition is maintainable, that a writ petition praying for demolition of an unauthorized construction is maintainable during the pendency of the suit. There is no quarrel to the aforesaid proposition laid down in Rampuria Brothers Private Limited, Supra. However, the said decision cannot come to the aid of the petitioner, as this court has only exercised its discretion not to entertain the writ petition in view of existence of an efficacious alternative appellate remedy as provided under the 1993 Act.
Grateful, my lord.
এইগুলা আগে দিয়ে দেবেন, লাস্টে disposed of with liberty. Any more judgments, Mr. Rai?
I shall not trouble your lordship, but this will be the law from tomorrow. It will be beneficial for us also in other matters. In other matters also, my lord, it will be beneficial for everybody.
No beneficial or prejudicial.
Oh, your
that
lordship
is for the matters to come.
My lord, I handed over.
Because after all, your lordship took the trouble to decide the matter, my lord. I am grateful to your lordship. I am grateful to your lord.
Tomorrow, my lord, single bench will continue.
That whose book is your book? That I do not know, sir.
My lord, 47 is my.
Because 46 is mine for such reason.
46
46.
to be taken up from 46 যেখানে শেষ করছি তারপর থেকে
47 is my application, my lord, instead of tomorrow, my lord, can it be day after tomorrow, my lord?
day after tomorrow 47 টা not today মানে not tomorrow করে রাখবেন
Fine.
চলো
আমাদের পেয়েছেন থ্যাংক ইউ কনস্টেবল যেগুলো সম্পূর্ণ তো